Just a just just a little housekeeping for the early arrivals. We've also arranged to have Coverdale 606 available again this week, this meeting. And the advantage to that is if you're in here and you feel like you're freezing to death, I have it on good authority that Coverdale 606 is much warmer. So if you feel like you're freezing in here, Coverdale I hear is much warmer. But we'll have that available for overflow. So just if you feel uncomfortable, that's an option. Thank you. Unless you're a respondent or a county official, and then it's not an option. Sorry, you have to put on a jacket.
Testing, testing.
Okay, you're number 2, so this must be chair. Test, 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 test. Okay, we got. Good morning. I'd like to welcome everyone to the meeting of the Georgia State Election Board. I'd like to welcome everyone to the meeting of the Georgia State Election Board on October 3rd. And I'm Matt Mashburn. I'm the senior member of the board, and we'll begin the meeting as the master of ceremonies, I guess. But we'd like to call the meeting to order. And we'll begin with the invocation and pledge of allegiance, and I'll ask Board Member Edward Lindsay to give the invocation.
Thank you, Mr. Mashburn. Please bow your heads. Dear God, we ask for the courage, wisdom, and humility today to act justly, love mercy, and walk humbly with you in our deliberations today on behalf of the great people of the state of Georgia. Amen.
I'm going to ask Dr. Johnston to lead us in the Pledge of Allegiance. Please stand, face the flag.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you. Please be seated. The first order of business before the board is to elect an acting chair. So at this time, I will accept nominations for acting chair.
Mr. Mashburn, I move that we nominate you as our interim chair until the governor appoints a permanent chair.
Thank you. There's been one nomination. Is there a second? Second. That nomination has been moved and seconded. Are there any other nominations? Is there a motion to close nominations?
So moved.
Second? Is there a second? Second. All those in favor of closing nominations, please indicate by saying aye. Aye. All those opposed? The motion to close nominations passes, and now the motion is on the question. All those in favor of electing Matt Mashburn as acting chair until the governor appoints a permanent chair, say aye. Aye. All those opposed? So Matt Mashburn is elected the acting chair. So thank you. I appreciate the confidence placed in me by the other board members, so thank you very much for that. And now we'll move to the remainder of the agenda. The first point on the agenda is the approval of the board meeting minutes. Has the board had a chance to review the minutes? Are there any questions or corrections to the minutes?
Mr. Chairman, I move that we accept the minutes of the August 1st, 2023 hearing.
There's been a motion to accept the minutes. There's been a motion to accept the minutes as written. Is there a second? Second. There's a motion and a second. All those in favor say aye. Aye. All those opposed? The motion to accept the minutes is approved. The next thing on the agenda is we would normally at this point move to cases recommended to be dismissed on the agenda, but we have received a conflict letter with an attorney who has an actual conflict for a hearing that he needs to get to, and so we're acting as a courtesy to the judge, courtesy to the parties as well, but a courtesy to the judge as well, so the judge doesn't have to rearrange the judge's calendar to accommodate us. So we're going to take those two cases out of order, and so those cases are SEB 2022371 Cherokee County, and SEB 2022-131 also Cherokee County. Mr. Jordan is one of the parties, and I'm going to mispronounce the lawyer's name. Thank you for correcting me. You're welcome to present from your chair. There's a little brass plate in front of you that should have a button that says talk.
Mr. Chairman, what issue are we going to take up?
Well, let's take up, Counselor, which one would you like to take first?
I believe we'll start with Mr. Jordan's case.
Okay, you can use the microphone now.
Okay. I believe we'll start with Mr. Jordan's case. I do not believe Ms. Blankenship has made it here yet. I think she's still stuck in traffic. So.
Okay, so as a convenience and a courtesy, we'll take Mr. Jordan's case first, and that is case number 2022131, and it's number 26 in your binder. Number 26 in your binder. Okay, is give y'all a second, Secretary of State's office to get going. I appreciate y'all accommodating the parties as well by taking cases out of order. I know y'all work on these very hard, so I appreciate y'all's accommodation as well. So if you're ready, I'll turn on your mic. We'll hear from the Attorney General.
Okay,
No, I'm sorry, we'll hear from the Secretary of State's office. I apologize.
Okay, good morning, Board. We'll start with SEB 2022-131, Cherokee County complaint against Richard Jordan. It's tab 26. So the Secretary of State's Office of Investigation received a complaint regarding an issue that occurred at the South Annex polling station located at 7545 Main Street in Woodstock, Georgia. This occurred during early voting, June 17, 2022, for the June 21st, 2022 election. It was reported that elector Richard Jordan was causing issues at the polling station. The issues rose to the point that resulted in a request for the police to respond. And the listed possible violations is 21-2-566, interference with the primaries, 21-2-567, intimidation of electors, 21-2-569, interference with poll officers, 21-2-597, intentional interference with performance of election duties, and 21-2-583, sub 3, removal or destruction of election supplies. So, though not part of the original complaint, Mr. Jordan did admit to taking a photo of his complaint form while he was inside the voting area. A clerk stated he observed Jordan take a photo of his ballot. Body camera footage captures Jordan taking a photo at the area he was filling, in the area where he was filling out his complaint form. Jordan had placed his ballot on the table while filling out his complaint. He denied taking a photo of the ballot. Woodstock Police body cam video shows the prohibition notice posted on the wall in public view. This notice warns the public that it is a violation of law to use your cell phone or other electronic devices while inside the polling area. Jordan claimed he was at the polls to vote. He had previously filed a complaint with the county and was told by Andover that his complaint is not a county issue. Jordan began questioning the polling staff regarding the QR codes and their training. He picked up an absentee cancellation form informing the assistant manager that he was with the Republican Party investigating voting irregularities. He later told Investigator DeWeese of the Secretary of State's office that he was not sure if he needed the form and was confused. His actions caused an assistant manager to have to leave her station and contact the manager. The manager then had to deal with the situation. A second manager observed the situation and grew concerned that it may escalate and had to leave her station to call the police. Jordan claimed that Woodstock police officers were interfering with him while he was voting after they arrived. Jordan stopped his voting process after he printed his ballot, and then instead of scanning the ballot, he carried it over to the manager and started questioning her concerning the QR codes. He could have completed his vote and then requested the complaint form. However, he chose to place his ballot on the table face up. He was told by poll personnel and workers to complete his ballot and leave the polling station. The police body camera footage does not capture the entire event. It appears that Jordan arrived and registered at 4:06 p.m. Woodstock police were dispatched to the scene at 4:22 p.m. Jordan left sometime between 4:30 and 5 p.m. There were no other complaints filed by the other electors that were present during the incident. The manager was ultimately able to retrieve the absentee ballot affidavit form. In looking at the police report from the Woodstock Police Department, I'm just going to briefly provide a summation of what was stated in that report after they were called. The officer was dispatched to a trespassing call at that location. He entered the building. He approached Mr. Jordan, who, according to the poll personnel, was being disorderly. He would not leave the polling station when asked to by the polling staff multiple times. He spoke with Mr. Jordan and asked, "Is there a problem?" He advised him he needed to leave the building per the polling staff's request. Mr. Jordan then threatened the police officer's job and alleged that the officer was looking at his votes. The officer told him that he needed to cast his vote and leave. Mr. Jordan refused to leave and continued to raise complaint about the voting station and staff. Furthermore, after a few minutes later, Mr. Jordan finally submitted his vote and left the building. The staff members were really frightened about the whole situation and advised that the male had been at the polling station for an hour or so, not submitting his vote. Staff then told him he needed to cast his vote and leave. Mr. Jordan argued with the staff and wrote a complaint about the situation at the polling station. And that was it. He indicated, see the body camera footage for more. So based on this incident, for allegation 1, recommended that there is not sufficient evidence to sustain a violation of Georgia Code 21-2-566, interference with primaries. Number 2, there is not sufficient evidence to sustain a violation of Georgia Code 21-2-567, intimidation of electors. Number 3, recommended there is sufficient evidence to sustain a violation of Georgia Code 21-2-569, interference with poll officers, which states any person, including any poll officer, who willfully prevents any poll officer performing the duties imposed on him or her by this chapter shall be guilty of a felony. Number 4, there is sufficient evidence to support a violation of Georgia Code 21-2-597, intentional interference with performance of election duties. Any person who intentionally interferes with, hinders, or delays, or attempt to interfere with, hinder, or delay any other person in the performance of any act or duty authorized or imposed by this chapter shall be guilty of a misdemeanor. Number 5, there is not sufficient evidence to support a violation of Georgia Code 21-2-583 sub 3, removal or destruction of election supplies. And finally, number 6, there is sufficient evidence to support a violation of Georgia Code 21-2-413 sub E, conduct of voters, use of photographic equipment or other electronic devices within a polling place. No elector shall use photographic or other electronic monitoring or recording devices or cellular telephones while such elector is within the enclosed space in a polling place.
Thank you for your presentation. Any questions for the inspector from members of the board? Dr. Johnston? Oh, sorry, let me get your mic.
I have one question. Was there any evidence that there were other electors at the early voting location while this was happening?
Let's see.
And the rough number?
Yes, I mean, it was an open and active polling location, yes.
Right.
Yes.
Okay. Do you know, do you have any sense of how many voters might have been present at the time?
Let me see if that's in the report. I don't see a number.
Okay. That's
Listed.
fine. Thank you.
Dr. Johnson had questions, I believe?
Question, Michael, was voting by others stopped or halted during this period of time?
It doesn't specifically say that, but the fact that these poll workers had to divert and go and address him and deal with him and call the police, just based on that, is one of the reasons why we listed those violations, because of the disruption that was caused by the totality of the incident.
Any other questions by members of the board for the inspector?
Not at this time. I may have some after the respondent.
Okay. Okay. And just to advise the board members, I've just turned on all the mics, so everybody's got a live hot mic, all right? Counselor, we're ready to hear what you might have for us, but one of the first things I'd like to do is we have a lot of people that watch these hearings over the internet and we live stream them, but one of the things I'd like to just explain to the general public is this board is an administrative body, so even if a statute says something is a crime, this board has no criminal authority to charge a crime or prosecute a crime. So we're an administrative body. We could send a case to the Attorney General's office where they would proceed administratively. We could return it, or we could send it to a district attorney, but that would be the district attorney's own individual decision to charge a crime. So this board has no criminal authority. So just, we'll use this case as an opportunity to educate the public and just let everybody know that. But Counselor, you ready?
Yes, I am. Thank
Right.
you.
Feel free to stand if you're more comfortable. Lawyers like to stand. Feel free to stand if you'd like to.
You're right. Lawyers like to stand. Respected members of the board, thank you this morning for giving me an opportunity to be able to address these issues. I have the privilege of knowing Mr. Richard Jordan. He's been a member of the Cherokee County community for his entire life. He's been involved in the governmental aspects of the county for probably at least half of that time, if not better. During that time, he's cultivated a reputation of sound judgment, of enthusiasm, and above all, a passionate quest for the truth when it comes to matters of government. I want to observe a couple of things. First off, in reviewing Inspector DeWeese's report, which is before you today, it is without question that Richard Jordan was present in the polling location that day in order to cast his vote. He was engaged in the process of casting his vote. Voting is a sacred duty and right in this country. It is a privileged activity, and it is certainly the case that before we are to interfere with an elector's right to cast their vote, there must be a really significant reason for doing so. I would submit to the board in this case that there was not in this case, and I will take these charges in turn, the ones that were actually recommended. Elector Jordan came into the polling station. He registered as he was supposed to. There were no questions at the time. He received his ballot. He proceeded to the ballot marking device. When he got to the ballot marking device and he printed out his paper ballot, which, as we all know, is what gets printed from the BMD, and you carry that and you insert it into the scanner, and that's when you vote. At the point that he printed off his ballot, paper ballot, he had a question. Now, what do we know about poll workers? And I'll go right to the statute here, the regulation. Poll workers are there in order to assist electors in casting their vote. It is not just a question of convenience. It is a matter of a positive duty on the part of the poll workers to be able to assist an elector who has questions about the ballot. And I'll read to you. At least one poll officer shall be assigned to assisting voters who have questions while they are in the voting booth, but before they approach the ballot scanner. This is exactly the point at which Richard Jordan asked his questions. What were his questions about? As the investigator has pointed out, and the affidavits of record point out, he had questions about his ballot. The right person to go to with questions about that ballot were the poll workers. And again, it was their job to answer those questions. The regulations are even more clear. A voter may request information from poll officers concerning how to use the electronic ballot marker or any other voting system component at any time during the voting process. It is undisputed that Richard Jordan was asking about the voting process. He had questions about the QR codes. At least one federal judge, Judge Totenberg, right over here in federal court, has ruled that that QR code is unintelligible to people, and Elector Jordan had legitimate questions about that. I will submit that what's going on here today is not a problem with what Elector Jordan's conduct was. The problem was the questions that he was asking. They were uncomfortable questions, and they did not want to respond to these questions. As further evidence that this is what was going on before the police were summoned, well, when the police were summoned and they got there, the evidence of record that the investigator has available to him shows the election supervisor, Ann Dover, coaching the police officers ahead of time, telling them when she was not there and she was not present that this man was causing a ruckus. Why was he causing a ruckus? The ruckus was that he was asking questions about the ballot and about the voting process. It is not illegal for this man to ask those questions. He is not interfering with election workers when they're doing their job to answer his questions. During that process, the poll manager directed Elector Jordan to speak with election supervisor Ann Dover. How did he do that? She put a cell phone in his hand. Our statutes are clear that the poll managers have the authority to be able to allow cell phones to be used, and I will quote the text, the statutory text of section 21-2-413. It says, provided, however, that a poll manager, in his or her discretion, may allow the use of photographic devices in the polling place under such conditions and limitations as the election superintendent finds appropriate. Not only did Richard Jordan have legal authority to be using that phone, but it was given to him by the poll manager. And this is what the investigator is coming and telling us is a violation. Board members, this is not a violation. What is going on here is fairly clear. Richard Jordan was being retaliated against because he was asking uncomfortable questions about the QR code process. What was going on here was that the poll workers were trying to tamp down on that line of inquiry. Now, there is some evidence that you haven't heard here today. You have not heard evidence that there were any voters around Richard Jordan when he was asking his questions. That is because there were none. Richard Jordan, and this is clear from the evidence from the body cam, Elector Jordan was directed over, away from the ballot marking devices. He had asked to fill out a complaint form. When he did not receive answers, no one could tell him the answers to the QR code question. So he asked to fill out a complaint form. He was sent to the stand-up booth where you fill out ballots by paper if you're unable to use the ballot marking device. So Elector Jordan was over there filling out his complaint form when in comes the police. Elector Jordan at that point is off by himself. He had spoken with the poll workers, the poll manager. He had not disturbed anyone else. There is no evidence here today. There have been no electors interviewed to say that they were in any way interfered. There is no testimony in the record, in the investigative report, that any of these poll managers were affected in any manner other than to be asked about this QR code process. That is the nature of the interference. That, respected board members, is not a criminal violation. That is his right going into there. Now, I do not know, and I'm not here to speculate on what's going on with Election Supervisor Andover, or why she would tell the police that he was creating a ruckus. But I am here today to say that what Richard Jordan did in that polling place was consistent with his privilege to go in and vote, consistent with his First Amendment privilege to question the government as to the voting procedure, consistent with Georgia statutes and consistent with Georgia regulations. And the fact that he is now being subjected to criminal charges is a travesty.
Well, again, the board doesn't have any power to impose criminal charges against anyone. This is an administrative hearing.
Well, in consequence, I would respectfully urge this board not to pursue this matter any further and to dismiss this matter against Elector Jordan. Thank you.
Thank you, Counselor. Questions for...
If I may, Counselor, is that Mr. Jordan there?
It's on.
I'm sorry, is that Mr. Jordan?
Yes.
Can Mr. Jordan come forward? Is he willing to come forward and answer some questions?
I would rather not speak this time. My attorney representing my...
Okay, well, the problem is, of course, I've got questions for you that only you can answer. So I'm just going to let you know that. So I'm going to direct the questions wherever you want me to, but you're the respondent, and there are certain questions that I have for you. So, Counsel, let me ask you this: Did Mr. Jordan vote in the 2020 election with the QR codes were there?
He did vote in the prior elections.
Okay, so he voted with QR codes before, correct?
That is my understanding.
Okay.
Georgia used them, so I assume he would have had to.
So he was aware that QR codes were being used when he went to the voting place to vote electronically, correct?
Mr. Board Member, I don't think that many of us in this room were really aware of what those QR codes meant back in 2020.
I understand that, but Mr. Jordan is active in his respective party, correct?
Yes,
And he is also someone who's very interested in the election process, correct?
absolutely. I
So,
think
Mr.
we all are now.
So can we assume that Mr. Jordan knew the QR codes were being utilized when he came to vote in the June? I'm having to make that assumption because your client's not willing to come and talk.
Yeah, no, I think it's fair to say that he was aware that there was a QR code. Even back in 2020, it was known
Yeah.
that they were used. But what I think what wasn't fully appreciated was the fact that the information on the ballots that we fed into the machine, it was not reading off of
Yeah.
what we could read. It was reading off of that code. And a lot of information has come to light since then, which is a lot,
The
as a
problem, the
consequence.
problem is you're making assumptions, and quite frankly, I'm left with the fact that your client was someone active within his respective party, as am I, for instance, had voted previously with QR codes, so was familiar with the fact that QR codes were there. And so I have to wonder if he was there to simply make a statement regarding his disagreement with QR codes, which we all have a right to do so at an appropriate time and place. The question is whether or not in the polling place is the time and place to do that. That's the problem that I'm having here. If Mr. Jordan was simply a citizen who had never voted before, shows up and sees a QR code for the first time, is not familiar with the voting process, has not been active on these sort of issues, I might have a little bit more sympathy than someone who does know this. And so it appears to me, based on the fact that Mr. Jordan hasn't been willing to come in and talk, that he was there, quite frankly, to make a statement about his disagreement with QR codes. Now, I understand folks, hold on, I understand folks having a problem with QR codes, and that's something that the legislature needs to take up, and some other people need to take up at the appropriate time. The question is whether or not making that statement at that time in a polling place is the appropriate time and place. We all know that we all have a right to freedom of speech. You and I are good lawyers, and we both want to adhere to that. The question is whether or not this is the appropriate time and place to do so. Understand my point?
Thank you. I do. I appreciate your point that you believe it's at least conceivable that Elector Jordan was there in order to make a political statement, if you will, about the QR codes rather than a legitimate inquiry.
Yeah.
I think the answer to this is fairly straightforward. Let's go to the evidence. Let's go to the affidavits that were submitted. If you review those affidavits, you will not find a single affiant talking about Elector Jordan making statements or preaching about his view of the QR codes. What you will find is him asking questions about how they operate. And for those of us, including Elector Jordan, who are not involved in the state's process with how these are selected or how the machines are devised or how the logic works, the only time that we really have to ask a question directly is when we're in that polling location asking the people who have been trained, and we know the poll workers are not allowed to work there unless they've received training approved by the Secretary of State's office. So that's what he was doing, is asking
Well,
questions.
The problem is that's not the only time he could raise that. You and I both know that. He could raise that publicly. He can raise that at appropriate meetings. I've had numerous people come and raise that issue right here at the public at the public inquiry times. I've had numerous people raise that in emails. I've had numerous people raise that with legislators who will be the ultimate determinant on such issues. So that's not the only time. The question is, was this an appropriate time? I'm sort of, and given the fact that what we do know about Mr. Jordan, I think it'd be reasonable to assume that he already was familiar with QR codes and he already knew about his objections before he showed up. And I'm sorry, but I have to reach that assumption because he hasn't come forward to talk.
Well, as you know, it is with great care and concern that one waives their right in the face of, if this board sees fit to allow this situation to continue, then my client is going to face criminal charges. And what you're asking him to do is, without being charged, to waive his Fifth Amendment privilege now. And that's not something that I take very lightly. And I think this board should be respectful of the fact that he has a Fifth Amendment privilege. And what we're talking about is him potentially facing not one, but 2 felony charges out of this. So without knowing more, I don't think it's
I
a
understand the
situation I would be
concern, Counselor.
comfortable. But I would encourage you, instead of speculating, as you've mentioned several times, to take a look at the evidence.
I haven't taken a look at the evidence, and I don't think I'm speculating. I think I'm making a reasonable inference absent your client's test coming forward. And keep in mind that this is a civil proceeding, and as you well know, the failure to, whether the assertion of your Fifth Amendment rights in a civil procedure is much different in terms of what an inference can be raised from a criminal. So as you're well aware. But that's 2 lawyers going back and forth, and I apologize to the rest of the crowd.
Mr. Chairman.
Other questions from board members? Dr. Johnson?
Yes, I have a concern with the allegations in this case, just because the evidence for 21-569 interference or preventing a poll officer from performing duties can be a very subjective decision, and also the violation of 597 interference with duties can also be a very subjective decision. So is asking a question interference? I don't think so. Is harassing poll workers the correct thing to do? No. I think we all need to be very aware that poll workers are there to conduct the election and not answer questions about the QR code or the voting system. They're there to assist the voters with voting. But do I think that this is a proper case for citing evidence of interference? Or I don't think so.
Well, I would agree with you, thank you. I believe the statutes are quite clear that it is the duty, it is the right of the elector to ask questions if they have them, and it is the duty of the poll worker to try to answer those questions if possible. Did they do their duty? It appears that they arranged for Elector Jordan to speak with Election Supervisor Andover. He was not able to get the answers to his questions. Eventually, he did not carry that forward. He asked to be able to fill out a complaint form. So I think the process here worked the way the process was supposed to work under the statute.
If I can,
Other questions from the board?
yeah, if I can ask the investigator to recount the timeline, exactly how long these events took at the polling place?
So it looks like Mr. Jordan arrived and registered at 4:06 p.m. So at 4:22 p.m. is when the Woodstock police were dispatched to the scene. And then he left sometime between 4:30 and 5.
So somewhere between 30 minutes and 1 hour.
Yes.
It seems to me that first, the role of poll workers. Now remember, these are generally virtually volunteers. These are people who are temporary workers who are there to assist people in casting a ballot. It is not their role to explain the policy behind the decisions of the legislature and the systems that were chosen. We're facing a crisis right now across the country, across Georgia, because we are losing poll workers, we are losing managers, we are losing supervisors. There is not a single metro county right now that is going to have the same supervisor in 2023 and 2024 that we had in 2020 because of the abuse that they faced. Just asking questions is a massive umbrella that can be exploited and abused. It does not take 30 to 60 minutes to ask a good faith question.
If I may, Mr. Chairman.
Members of the board, if you would permit me to speak, I'm Ann Robaugh. I am the attorney for the Cherokee County Board of Elections.
Hang on. Question, just a question. Let us finish with the counselor and the board members' questions for the counselor, and then we'll take, the board will take that up.
Mr. Chairman, I really think that this board would benefit from hearing from Mr. Jordan, and so, thank you very much. Sorry. I think the board would benefit from Mr. Jordan, and in light of the attorney's concerns over the criminal, I'm going to move to dismiss the criminal aspect in terms of, which would only give us the power to refer to the Cherokee County DA anyway, and then take up the remainder. So I'd like to make that motion at this time, and then let's sort of deal with, and then let us deal with the civil aspects.
Okay. Can you
I'm going to move to dismiss the evidence of the criminal aspects contained in number 4, in charge of 21-2-597.
so that the count would still be pending, but it would be stripped of any criminal evidence? Is
Yes.
that
That's what
is
I'm
the
looking to
correct statement of
do.
your motion?
That's what I'm looking to do. Strike it from any criminal aspects.
Is there a second to that motion?
Question.
We need a second first. Is there a second?
Second.
Okay, there's a second to that motion. Now discussion.
I'd like to add to that to drop 569 also. I'd like to amend the motion to dismiss violation of 569 also.
Make sure I correctly understand it. We're not moving to dismiss the count. We're dismissing to strip it of any criminal.
That's all I'm doing, Mr. Chairman. I would ask that we simply limit it to that at this point. There may come a time to look at the other charges, but I'm just simply looking to dismiss the criminal aspects.
Okay, so there's been a motion and a second to retain the count, but to strip it of any criminal aspect. All those there's been a discussion. All those in favor would say aye?
Aye.
All those opposed? So the motion carries, so that count continues, but stripped of any criminal aspect.
Counselor, with that, I'm going to once again offer your client an opportunity to speak now that the criminal aspects have been removed, and ask whether or not he would be willing to answer my questions, or does he continue to waive and simply go with his lawyer? Okay.
With your permission.
Okay.
One second.
We have a slight recess.
Respected board, under those conditions, my client will speak.
Someone else can hold it.
Yes, sir. What could I,
If
what
I can,
questions
Mr.
could I
Jordan,
answer?
just to ask a few questions. And political party doesn't matter to me unless you want to state. You've been active in political parties for a number of years, correct?
Since 1962, when my father served as state representative here at the Capitol.
I think that qualifies. How about yourself in terms of your activities in public
I was
office?
elected in 1980 as the youngest judge ever to serve the people of the state of Georgia, and I was appointed for my second term as a state magistrate.
Okay, congratulations to you. And in regards to, I asked your counselor, you voted in the 2020 election when QR codes were being used, correct?
I did.
And you were familiar with the fact that QR codes were being used, correct?
I learned at the polling place that indeed they were used, and thereafter I found out that there was quite controversy over the use of those because of the inability to read them or verify the actual written
Understand.
responses in English versus the QR code, which is the only thing that's recorded on the flash drive that's sent to the Secretary of State's
Understand.
office. Yes, sir.
And that's an issue that is being debated at this time, both in courts and in the General Assembly and elsewhere. And this was in 2020 that you became aware of that, correct?
Probably
21?
21.
Yeah.
You know, when all the,
So when you came to vote in 2022, you already knew that the QR codes were going to be on the ballot, correct?
I assumed they would be. We
Yeah.
had, for 2 years, we had attended the monthly meetings for the Board of Equalization, the Board of Elections
Yeah.
at Cherokee County, and we were not able to get any sufficient answer after multiple responses, requests for responses at the 2-minute inquiry period of open to the public.
Yeah. So you and others had raised the objection to the QR codes before,
I had not personally,
but you had observed other folks doing so.
There were a group of citizens that were concerned,
Yeah.
mostly I call them mama bears, that were very concerned for their families and their children
I understand.
and of course, election integrity in general.
Yeah. And so when you voted and when you came to the voting place in I guess it was the primary 2022, you knew the QR codes were going to be being utilized. And would it be fair to, so what was the purpose then, as opposed to, you also knew that you're being a sophisticated voter. You also knew that you had the option to vote by absentee, which would not have the QR codes, correct?
That's the reason I picked up the ballot cancellation form.
Yeah.
And I was reading it after I marked my
Yeah.
ballot. I was reading it, I paused, and one of the poll workers came up to me and said, "Sir, can I help usher you over to the tabulator to deposit your ballot?" And I said, "Well, ma'am, how do I know for certain that this QR code accurately reflects my candidate of choice?" Sincerely, a legitimate question. She said, "I have no idea."
Yeah.
I said, "Can I speak with the poll manager?" She said, "Sure." She was walking me over, so I walked on over. I think her name was Miss Waddell. I asked her the same question. She said, "I don't know." I said, "Would it be okay if I fill out a response form, a complaint form, and get an official response back from the Board of Elections as to what the official policy is in my county, Cherokee County, with all the controversy going on, as to why we continue to not give an alternative method of using a paper ballot?" And so that was what created the confusion when I picked up the ballot cancellation form. And so I was trying to understand, could I cancel it if I don't get a correct answer or get an appropriate answer or a legitimate answer? So that's when I walked over to the table to fill out the complaint form. And as I was doing that, the poll manager put her cell phone in my hand and said, "Election Director Ms. Dover would like to speak with you." So I spoke with her, and she basically said, "There's nothing I can do. You'll have to talk with your state legislator," and began to.
Good advice, yeah.
And so at that point, I thought, well, if I can fill out this response form, this complaint form, and get a response from the Board of Elections, that would satisfy me, and so I don't need to cancel my ballot.
Okay. The taking the photograph, you took a photograph of your complaint, or did you take a photograph of your ballot?
of the complaint form. After I was given consent by the election director and the poll manager to use an electronic device as I was perfecting my vote while standing there at the table trying to vote, until I was interrupted by 2 armed police officers standing up next to my side, demanding that I leave the premises after I had been given consent to perfect my vote and to actually complete the complaint form. So matter of fact, it embarrassed me. It disturbed me at the point when I'm trying to exercise my sacred right to vote, my constitutional right. So therein lies the question as to why I felt accosted almost, like my vote was actually being, was being suppressed. And so, but I was able to fill out the form. It took me about 5 minutes to fill it out in longhand.
Okay.
At which time, and I had my German short-haired pointer with me. I said, "Come on, Daisy." And so I had asked the police officer to stand, 10 or 12 feet away as my ballot was in full view on the table as I was voting, and he was observing my ballot. And so he did, he complied. And so after I left, I asked for his name and who he reported to, so that, so that I could have an account of this process. I was the only one in there that can corroborate my story had it not been for the police body cam.
Okay.
All the rest of the poll workers were paid. Yes, they were volunteers. They were volunteering, but they were paid. I was the only one not being paid, so I was exercising my civic responsibility to vote my conscience.
Okay. Any questions?
Other questions from other board members? Sarah? Dr. Johnston?
So, Mr. Jordan, you were given permission to take a photo of your complaint? Were you
I'm
given,
sorry?
Were you given permission to take a photo of your complaint?
There was it was documented when I spoke with Election Director Dover on her phone at their direction, their consent to use an electronic device to document this process. To fully document it, yes, I had to make a photograph because I didn't know where or if that complaint form I didn't know where it would get because I didn't know where it would go. So yes, I needed to document it, and I did document it with my phone after I was given permission and consent from the poll manager and the board of the elections director.
I want to make sure I understand. So you're saying that you were given permission to take a picture of your complaint?
I was given consent to document the process of speaking with Election Dover on the phone, letting her know the reason I was filing a complaint form to document it, at which time the consent was to go ahead and fill out the form. But the form cannot be documented because they did not have a copier available. I just wanted to make sure that since I was given consent, that I could I took a copy of it because I needed to confirm that. I was the only one there that could corroborate my story.
All right, let me ask it again directly. Were you given permission to to pull out your phone and take a picture? Yes or no?
I can't answer that yes or no. I can say I was given consent to use an electronic device to document the voting process at that point.
I'm not sure why you can't answer my question. I understand that you talked to the folks back at the Cherokee County Board of Elections. I understand that they wanted to talk to you. What I don't understand is whether or not because there is that prohibition against using, absent someone saying, "Oh yeah, you can take a picture of your complaint, or you can take a picture of something else." Absent someone telling you that, that's what I want to know. Were you given permission, one way or the other, to take a picture of the complaint?
Sir, I did not ask for permission.
Okay,
I was
that's fine.
given consent.
That's fine. I understand. Thank you.
Other questions from the board? I have a couple questions, if I might.
Yes, sir.
Did I understand, and you're not under oath, but we do have expect you to tell the truth, but you're not under oath.
I would do nothing otherwise.
I appreciate that. But it's important that you be square with us. But I understood you to say that you asked one question of one person, and then you asked a second question of a second person. Is that correct?
The same question.
Okay.
How do I know for certain that this QR code accurately reflects my candidate of choice?
And there were no other questions?
No other questions.
Okay.
Except that, can I fill out a complaint form? I asked the poll manager which time. She said, sure. And she walked me over to the table. And then that's when the phone call came in, and that's when I was filling out the form and was accosted by a couple of armed police officers while I was exercising my right to vote.
I got that. So, but you would probably agree that it would be improper to ask a poll worker questions about policy. Do you agree with that?
About politics?
Policy.
Policy. That's the reason that I wanted to document in a complaint form. If they could not answer it, I wanted to document so I could get documentation back as to what is the official policy of my Board of Elections in my county, that as a taxpayer, I pay those appointed officials to determine, and even stipends are paid to the Board of Elections members. They choose to serve. And while they're serving, I expect them to fully evaluate what their rights and what their oath of office is as Cherokee County residents. They've taken that oath based on what the Secretary of State has related to them in the way of policy on the state level. I'm asking, what is the policy of Cherokee County? Is there an alternative? The question is there an alternative paper ballot measure? I was not given any other option. I just asked the question, and
But you didn't ask those questions, is your testimony, right?
no, but I was looking at the ballot cancellation form because I didn't know if that was an option. That's what I was looking for. Is that an option?
Okay, thank you. The board is entitled to hear from witnesses that it would like to fulfill its investigation. That is one of the, or determination, that is one of the rights that the board has. So if it is the pleasure of the board to hear from Cherokee County, I'll entertain that if that is the board's will.
I would ask for that.
Okay, by unanimous consent, so ordered, Counselor. If you'd like the microphone, you've got a button that says talk or speak or something. I see you. There you are.
Hello.
Let's test it and make sure you're on.
Good morning. I'm sorry, didn't mean to interrupt.
You have the floor.
My name is Ann Brumbaugh. I am the attorney for the Cherokee Board of Elections. With me today is Ann Dover, 2 staff members, and one of our board members.
That was me. I was trying to turn you up a little bit. Sorry. Let's try it again.
All right. Are we good?
Let's trust.
Okay.
There you go. Okay.
With me is Ann Dover, the election supervisor, 2 staff members, and John Wallace, who is a board member. He is a new board member as of July 1st. We are here today on another matter. We were not planning to speak on this. None of the poll workers that were present at the South Annex that day are here with us. What I would like to do is add some details to the record that neither side has presented. And I would also like to say at the outset that Dr. Johnston is correct. This is a very subjective standard, and unfortunately, there is not any case law to help you interpret it. But so you have to ask yourself, at what point does asking questions cross a line? And the evidence that we haven't heard today is that this was not the first time that Mr. Jordan had done this. Mr. Jordan went to a different precinct on the Friday before the May primary and made questions. The police were not called at that time. A statement was made. I believe he talked to you that day too. He was asking the same questions. It was handled. We're not here on that day. 3 weeks later, 4 weeks later, now we're at the runoff, comes into this precinct, and he starts doing the same thing, but he escalates it. And I don't know if you've seen the statements from the poll workers, but they were scared. This wasn't just questions. This was people who were unable to do their work because they were so frightened. And that's how the police got called. I think that if Mr. Jordan had kept his behavior to where it was at the May primary, or if he had simply asked 1 or 2 questions, we wouldn't be here today. But this was a situation which compelled people to feel that they needed to call the police. It scared them. It prevented them from being able to do their jobs. And so I think the issue, and if you haven't seen those statements, then I would ask you to maybe adjourn and read those statements. I don't know what you get and what you don't get. But I think that the context really has not been fleshed out on either side, and that it is important to decide whether this went to, went beyond just asking a question or two and went to the point where people couldn't do their jobs and they were scared, and they would be scared if Mr. Jordan came back into their precinct. And I would also state that Ms. Dover did not give Mr. Jordan consent to use an electronic device on the phone when she talked to him that day.
Questions for the board for Cherokee County?
I have a quick one. I know you're not here to speak on this, Ms. Dover, but can you speak to the impact that this has had on your work as the election supervisor?
Yes, ma'am.
Hang on. Okay, give it a try.
This one? You got me? Yes, ma'am. The poll workers at this polling location were very intimidated. Some of them have decided not to return because of this incident. I'm fearful that this sets a precedent for people to continue to treat poll workers in this manner. As an elections official, I know of several that have quit because of treatment that we're receiving, and I think it's very important that this board hears what poll workers are saying and what elections officials are saying, because what's going to happen is you're not going to have poll workers and you're not going to have elections officials if we continue to be abused.
Thank you. I'm going to use this opportunity to just make a statement like I usually do, which is casting aspersions on the good work and the goodwill of our election supervisors, our managers, our poll workers, is incredibly counterproductive. And we have to have the infrastructure to be able to carry on this work. And making suggestions that they have any motive other than running smooth elections is not supported by the facts, and it is insupportable moving forward.
Counselor? Make sure you're on. You're not on. Punch your button again. I got you. Okay, let's test it.
Thank you.
There you go.
With all respect, certainly our county election workers have a job to do, but no less important in the scheme of our country, in the scheme of our Georgia Constitution, in the scheme of our federal Constitution, is the right of individuals to vote, is the right of individuals to be informed about the process, the right of individuals to ask questions during the process. And frankly, a suggestion that by asking questions, legitimate questions, because electors don't understand the intricacies of these systems that we depend upon our elected representatives to select and implement for us. The fact that you would say that we can't have these people asking questions because they're going to interfere with this process is an offensive one, with all respect.
Yeah, let me ask you this, Counselor. The folks from Cherokee County said that he raised similar things at the previous voting time period. Is that correct?
His
that correct?
questions had never been answered.
I understand that, but had he raised, was
Had
it
he
something
asked
that,
a
was
question
this something
before?
that he had done before? Yes or no?
He had asked questions before about the election
And this
process.
time,
He is,
and this time we were dealing, so
And
this was
involved.
not the first time that he had been at a polling place doing this. This time apparently it escalated somewhat, correct?
I
Please
think
recall.
that if you go back and reread the affidavits, you'll find that there's
I've read 'em.
only one or two of those people that claim that there was something that went on. The rest of them say they didn't notice anything, they didn't see anything, there was nothing unusual that they noted. There were one or two that apparently raised an issue, but it certainly wasn't all of them. And there's plenty of evidence in there from which to conclude that Elector Jordan didn't really interfere with anybody.
Right.
Nor is there any evidence in this that it held up the voting process at all for anyone.
Like I said before, Counselor, there's plenty of opportunities for folks to raise their concerns, and QR codes are a matter of public debate, and I appreciate that public debate. And there are a lot of serious questions that are being raised. The question is whether or not in a polling place at the time of voting, with people who aren't involved in the public policy issue, if that's the time of the place to do so. Thank you.
Thank you.
Any further questions by members of the board?
Yes.
Dr. Johnston?
Just a comment. Again, I'd like to say that the determination of whether there's a violation of either of these statutes is very subjective. I celebrate the right to free speech and the right to ask questions. We have people that come here every meeting and speak and ask questions. So it's not that you can only ask them one time, okay? You can ask them every time you go to vote, I suppose. But I do expect and I do want people that go to vote to be courteous, respectful, and treat the poll workers just as if they would want to be treated. And I would hope that the poll workers don't fall for this narrative that's being set up to use words like escalate, frightened, scared, without good reason. Was there a physical threat? Was there really intimidation? Was there really abuse? If there really is verbal abuse, we want to deal with it, but I don't want things to be made up.
This time, if the chair is inclined to hear a motion, if there's a motion,
Chairman?
Dr. Johnston?
I do not find that there's sufficient evidence for violation of 569 or 597, and I would recommend dismissal with a letter of instruction to Mr. Jordan.
There's a motion for a dismissal with a letter of instruction. Is there a second? The chair hears no second. The motion does not pass for lack of a second. Are there any other motions?
I move that we refer this to the Attorney General's office.
There's been a motion that the matter be sent to the Attorney General's office for processing. Is there a second to that motion?
I would narrow that, Mr. Chairman, to, thank you. You're right. Got it. Move to refer to the Attorney General's office regarding 569 and 597. And I'll tell you where I'm going to go here. I'm going to ask for a letter of instruction to Mr. Jordan regarding the photographic aspects. I don't necessarily think that needs to go to the Attorney General, but the first two, I think, do need to go to the Attorney General.
Okay, that's been the chair views that as a friendly amendment. Member Gazelle?
Yes, I agree to that.
Okay, So we'll take that as a motion and a second. Mr. Lindsay, if you wouldn't mind restating your motion just so the court reporter has it clearly.
Just for the court reporters, regarding the potential violations cited in regards to 21-2-569 and 21-2-597 regarding the civil aspects of that, of these violations, I would refer that to the Attorney General for further consideration.
Everybody clear on the motion? Any questions with regard to the motion? Any discussion? All those in favor of the motion would say aye.
Aye.
All those opposed would say no.
No.
The motion carries.
Mr. Chairman, regarding the third aspects, the photographic, folks, stop taking pictures. But I'm not, I don't think that necessarily arises to the level of the Attorney General in this particular case, so I would move to dismiss with simple letter of instruction to Mr. Jordan as, informing him of the law and instructing him not to do it again.
There's a motion to dismiss with a letter of instruction the photographic count. Is there a second?
I'll second.
There's been a motion and a second. Is there any discussion? There's been a motion and a second. There's no discussion. We're ready to vote. All those in favor would say aye.
Aye.
All those opposed would say no. It carries unanimously. The motion carries. Counselor, thank you for your presentation. You were well prepared and made a very impassioned argument in favor of your client. You did a really good job for your client, so thank you for your presentation today. But we're ready to move to your second case if your client has arrived.
Yes.
Ms. Blankenship, welcome. We're glad to have you. Hope it wasn't too much trouble to get here, but we're glad you made it. Counselor, no, we'll begin with the Secretary of State's presentation. If you'll give us the case number and the tab number, please.
Tab 33, case number 2022-371.
That would be tab 33, 2022-371. Okay, we're ready for the presentation of the Secretary of State's inspectors, please.
The Secretary of State's office opened this investigation on December 30th, 2022, following a complaint from a Cobb County resident. The complaint reported observing a Facebook posting from a Tennessee resident, Sharon Anderson. Anderson reposted her daughter, Jessie Blankenship's posting that read, "Anyone need help in order to get out and vote? Seriously, gas money, a ride, a cup of coffee, a hand to hold till we get inside, of course. Election day is November 8th, 2022. Let's make history together." The allegation of vote buying made against the respondent was substantiated. There is sufficient evidence to suggest that the respondent violated the law that prohibits the giving or receiving, offering to give or receive, or participating in the giving or receiving of money or gifts for registering as a voter, voting, or voting for a particular candidate when she offered such services on social media. In addition, Blankenship admitted the Facebook site was hers and advised she would take the post down. Anderson confirmed that she reposted her daughter's posting, but had taken it down by the time the investigator spoke with her. There is substantial evidence to support that Jessie Blankenship violated Georgia Code 21-2-570.
Questions for the Secretary of State's office from the board?
Can you confirm the date that the posting was taken down?
When it was taken down? Let's see. On February 27th, the investigator made contact with Blankenship by phone. And when after he identified himself, he explained the reason for the call. The posting was observed on another site that appeared to be her mother, and that she had, on March 6th, it was taken, he contacted the Tennessee resident, and she admitted that she reposted the post. It didn't say exactly the date that it was taken down. but
Okay,
that she
so
had
about
taken it down.
2023. That's right?
Guess, how long was it up and when did it come down?
How long what?
How long was it up and when did it come down?
Well, we got the complaint on the 30th, and he didn't start working on that case for a week or two, so by the time he made contact, it was taken down when he contacted her. So, within a month.
Okay. And this was well before the election? When was the election at issue?
This was the 2020, just to clarify, this is a November 2022 election, but the complaint wasn't, the investigation didn't start till 2023.
Yes.
That's right,
Okay.
so, yeah.
Okay, all right, thank you.
Further questions from the board for the Secretary of State's office? Okay. Counselor, you ready? We'll hear from you.
Thank you, respected board members. My client, Jessie Blankenship, has been a lifelong resident of Cherokee County. She has no special skills, training, or knowledge in the area of elections or election matters, but like so many people, she is enthusiastic about our right to vote and other people exercising their right to vote. There is confusion in the law of the state of Georgia. Like many other states, the state of Georgia does not have an explicit prohibition against arranging rides to the polls. As a consequence, there are numerous organizations that have moved into this space. I can name but a few of them. There is, and in just a little bit of looking, the Arthur Blank Family Foundation offers assistance to people that are trying to get to the polls. The NACA offers has conducted a voter mobilization campaign in which they offer rides to individuals in order to get to the polls. There's an organization called Ride Share to Vote, also offers assistance to people needing rides to get to the polls. All of these organizations are dedicated around one intention, and that is to be able to assist people that want to be able to vote, to get there to be able to vote. There is nothing wrong with this activity. Certainly the state of Georgia has not legislated against it and has not prosecuted this activity. In fact, there is strong federal law supporting this and indicating that, and I'll direct you to 11 CFR 114.4, which has to do with, excuse me, one moment. Which permits organizations engaged in Get Out the Vote drives to offer and provide transportation to the polls or places of registration. So all of this together points out the fact that it is the policy in the state of Georgia and across the nation to be able to assist people when they need to get to the polls. Now, yes, Georgia does have a law against buying votes. And we know that because we don't want politicians getting into office by offering $1 to any voter who is willing to go out and sell their vote and get them into office that way. But if you look at the evidence that's been presented by the Secretary of State, we're looking at one Facebook posting, which was, even by their own statements, a private posting. It was not broadcast to a broad area. It was sent to my client's relatives, family members. And the gist of it, if you look at it again, I'm sure all of you have seen it. Sorry, She says, seriously, gas money, a ride, a cup of coffee, a hand to hold till we get inside, of course. Election day is November 8th. I do not believe that there is anyone looking at that can understand that posting as anything other than trying to assist someone to get to the polls. That is exactly what Georgia law permits. I believe that what the Secretary of State is focused on is the statement gas money. Specifically, they're only focused on half of that statement, money. And because it mentions money in there, they are now bringing this charge, potentially charging my client with a felony because she had the audacity to attempt to help family members get to the polls. But this is exactly what we allow all of these other organizations to do. Now, what is going on here? The problem here is the law of Georgia is not clear on this issue. We tolerate all of these organizations. Indeed, we encourage all of these organizations, as the federal law states, to help people get to the polls. But we do not give anyone clear guidelines of where this is acceptable or where this becomes across the line into some sort of vote buying. There is no evidence in the record to indicate that my client paid anything to anyone or that she actually even provided a ride to anyone. What she did was had a Facebook post up for a little while. When it was brought to her attention that there was a problem with it, she took it down. And that is what the evidence here shows today. It does not show that she's engaged in some nefarious vote-buying scheme for a politician in order to put them into office. And that is clearly what the statute is intended to stop. That is not what's going on here. And as the Arthur Blank Family Foundation full page on the internet today, you can go out there. They offer payment for a Lyft ride 2 ways to get to the polls. And I ask you, how is that different than my client offering a ride or gas money if you need that? So let's focus on the first half, which is the gas, which is to get to the polls. She's not buying a vote. What she is doing is enabling the transportation. Now, is this 100% clear in our law? No, because we have no regulations on this. We have no statutes on this. So in this particular case, here today, what I'm asking this board to do is to issue some sort of instruction so that my client, along with everyone in this room and lots more like her, know what it is that they're allowed to do. Because if you look out on the internet today, she had no reason to believe that what she did was wrong, given what's out there today. So thank you.
If I may, Mr. Chairman.
Questions from the board, Mr. Lindsay?
Your client is a private individual, correct? She's not part of any organization?
Yes, in this case, she's a private individual.
Yeah. The fact of the matter is, we have gotten consent orders from folks who thought they were acting good nature, or rather being good citizens, but did raffles and whatever else if someone would show that they had voted, or offered a Chick-fil-A sandwich if someone showed up with their certificate. I may even disagree with some of the contents of the law, but that was the law. But if it was an organization we're doing so, we have done a consent order. Your client, however, is a private individual, and clearly it is a little bit more ambiguous. And we have, in case you want to know, tried to clarify the law on where the line is. We've taken up numerous cases recently involving folks who are giving out free gas at a gas station versus offering to put people in a lottery and whatnot. Mr. Chairman, at the appropriate time, I'm going to move to dismiss this one, but do so with a letter of instruction. Now, let me ask you, you can ask your client, go through you. She won't do this again, will she? No. All right, that's all I want to know. Ma'am, you were not going to do this again, are you? No. All right, that's what I want to hear. At appropriate time, Mr. Chairman, I'll move to dismiss, but with a letter of instruction, simply clarifying what the law is, what you are and are not permitted to do, and then we'll move on to other matters.
If there are no other questions from the board for the counselor, then Mr. Lindsay's motion is in order. There's been a motion to dismiss. Is there a second?
Second.
There's been a motion and a second. Is there a discussion?
My only comment is to add that I would continue to encourage folks to give rides to the polls. It is 100% lawful. It is a fantastic civic opportunity and duty, and I would encourage people to continue doing that. You just can't give cash. Okay. I mean, that's just offer rides. It's great. No cash.
So there's been a motion and a second. Any further discussion? There's been a motion and a second. No further discussion. We're ready to vote. All those in favor would say aye.
Aye.
All those against the motion to dismiss would say no. The motion carries. The matter is dismissed with a letter of instruction. Counsel, if you do me a favor, if you will call the judge and say you're done so they can work on their calendar, I'd appreciate that if you wouldn't mind. Thank you, thank you. All right, so who's got the time?
It's 10:30.
All right, so we've been at it for an hour and a half. This is a good time for bathroom breaks, I think. So if everybody would appreciate a short break, we'll break for 15 minutes. I'm starting to feel the room getting a little bit colder, so if you're uncomfortable with how cold it is, Legislative Office Building across the street, 606, is set up to have this hearing broadcast, and it's a lot warmer. So if you're worried about the temperature, we'll do that. We'll be adjourned. No, I got it.
Yes.
probably thinking that that's like, but didn't they dismiss Herschel Walker being the gas? Huh? Okay. No, wait, if they dismiss Herschel Walker being the gas power,
I'm going to invite everybody to find a seat. Going to invite everyone to find a seat. I'm going to invite everyone to find a seat. If we can't get going, we're going to be here till midnight. Thank you. Thank you. Now we've moved to the part of the agenda where cases are recommended to be dismissed. Just for those that are watching that may not be familiar with the board's rules, what we traditionally do is handle these in bulk unless a board member would like to have a case pulled out and have particular discussion about it. If we could have order, please. If we could have order, please. Thank you. Thank you. Okay, so case is recommended to be dismissed. We proceed in reverse seniority. So Dr. Johnston, you got the first, if you'd like to pull any out.
All right, thank you. Thank you, Chairman. I'd like
Wait, sorry. Okay, go ahead. I'm sorry.
case SEB 2020-086
2020-086
and 2022-262.
2022-262. Are there any other cases that the board members would like to pull out?
Yes, 2022-237.
237. 237.
Tab number 10.
I don't see that.
I think that's 227.
Yes, in fact it is.
227.
227. Okay, very
I need to
good.
bring my readers.
And also, SEB 2021-85, tab 4.
85. Okay. I ask unanimous consent that we'll just take them in order that they appear in the binder, if that's okay with everybody. Sure. Without objection, so ordered. Okay, Secretary of State's office, you're up on case number 2020-086, please. Tab number 2, correct.
Okay. The Office of the Georgia Secretary of State's reported to the investigative division that complaints were received that multiple Floyd County polling places open late, potentially violating OCGA 212403 regarding time for opening and closing of polls, problem with ballots, not having precinct assignments during the duplication process, and potentially violating OCGA 212483 sub F, preparation of duplicate ballots, and SEB Rule 183-1-12-.18, provisional ballots and inadequate emergency ballot at some precincts, potentially violating SEB Rule 183-1-12-.11 sub 2 sub C, conducting elections. So after looking into the complaints, the investigation was unable to identify any of the original complainants or eyewitnesses to substantiate or corroborate any of the allegations received by the Secretary of State's office. The investigation found that at the opening of the polls, technical equipment issues were discovered, which caused a delay in their use. Statements obtained from those involved indicate that the polls were open on time. However, due to the equipment issues, emergency ballots had to be used until the equipment was functioning, which was about an hour after the opening of polls. As a precaution, an attorney obtained a court order to extend the closing of the polls. The allegation that the polls were not open for voting at 7 o'clock is unsubstantiated. Statements indicate that emergency ballots were used until the equipment issues were resolved. The investigation also found that during the duplication process of ballots, the duplication panel was provided erroneous instruction from the election supervisor about how to process the ballots. The panel was instructed to use a ballot from any of the precincts if they ran out of a particular precinct. However, there is no evidence to suggest that this was followed through with action. Statements from panel members indicated that they did not have a need to use incorrect precinct ballots during the duplication process. The allegation that incorrect precinct ballots were used during the duplication process is unsubstantiated. The allegation that polling sites ran out of provisional ballots is also unsubstantiated. Poll managers who were interviewed by Investigator Braun stated that they had a sufficient supply of provisional ballots throughout the day. Election staff stated that some polling sites had to be resupplied throughout the day, but that none of the sites ever ran out of provisional ballots. One of the questions we ran into with this particular case was the opening of polls at 7 o'clock. In this case, the poll was open, it's just that they had technical issues. And in looking at the statute, it says that they have to be open at that time. So that's one of the indicators as far as why we weren't able to find evidence that they weren't open at 7 o'clock.
Questions from the board?
So my issue with this case is actually about opening of the polls. The report states that 50% of the polls were not able to open at 7 o'clock, which is an alarming percentage of not being able to open on time. And also the rule states, or the statute states, that when we talk about opening the polls, we mean ready to vote. So it's not just opening the doors and having people walk in and stand around for 30, 45 minutes. So they should be able to go in and cast their vote. And this ended up resulting in a court order for the polls to remain open at the end of the day. And when I asked, I was informed that it was because the provisional ballots were not used. The emergency ballots were not used. So my question would be, was there an issue that there was not training for the polling places to immediately begin using paper ballots so that voting can commence at 7 o'clock in the morning and not inconvenience the voters?
That a question, Dr. Johnson?
The question, if there's someone from the county that would like to speak to that, I would be happy to hear a response.
Floyd County is the respondent, and so is entitled to be heard. If anybody from Floyd County is here as the respondent, they've been notified that their case was on the dismissal calendar, so it's frequently that the counties don't show up if they've been notified they're on the dismissal calendar, so it's not unusual. But if you'd like to be heard.
Mr. Chairman, I had similar questions to Dr. Johnson in terms of the sheer number of polling places, and also the question, let me ask you this, perhaps the investigator knows the answer to this. Were there contingency ballots that were immediately available to a voter to start voting at 7 a.m.? Because it gets back to Dr. Johnson's point, you know, to say your polling place is open but you can't vote doesn't, your polling place is not open. I mean, so do you know whether or not they were contingency, paper ballots?
They had the ballots, but in looking at the report, there was some confusion as far as implementing them. So there was an issue as far as the confusion, and that's why there was some delay until they got things. I think they kept trying to get through the technical aspects of things, and then, you know, finally they figured out, you know, obviously it's what the law says is use the emergency ballots, and that's what they did. So it just took a little time.
So, if I might, I think there's a training issue here that the counties need to understand that and the Secretary of State's office needs to reinforce as we're moving forward, since we do have so many new election supervisors, that it is critical that emergency ballots are made available to voters at 7 a.m. if their machines are not working. My concern was with some poor instructions, which luckily the panels that were undertaking the duplication recognized were wrong instructions. My note here, I'll let everyone see, is no, 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 no. which is if you're duplicating a ballot, you must use the same precinct ballot. You cannot use any random ballot. Those are tracked. The legislature in SB 202 required additional information on each ballot to have the name, not just the precinct code on that ballot, so we would know how many ballots are cast from voters from which precinct. That is an important piece of data. You cannot substitute, and this is for anybody watching, you cannot substitute a ballot from a different precinct to replace one that you're duplicating from precinct A. You can't use a precinct B ballot because it will not balance out. You will not have the same number of voters from each precinct and ballots from each precinct, and that, you can't do that. You cannot do that. And again, there is a districting error issue which appeared not to affect any votes or any voters, but when there are districting problems, that is generally comes down to ballot proofing. And I'm pretty sure every single meeting we've had, the last 6 meetings, we've had issues with ballot proofing. So again, this is absolutely critical because it leads to cascading failures, which leads to data not making sense. Counties have got to double down and really be incredibly careful when they do the ballot proofing. And I will step off my soapbox for the moment.
For these reasons, Mr. Chairman, I'm going to move to continue this to the next calendar. And let me, in doing so, because I'd like to hear from Floyd County, and let me, in doing so, both to the counties who are here today and to the counties that are listening in, and hopefully to Floyd County that will get a chance. If you have an error like this, if you come before us and you sort of lay out, okay, we see where our mistakes were made, but, you know, here are the instructions, here are the steps that we're going to be undertaking immediately, or we have already undertaken to make sure it doesn't happen again. We are far more willing at that point to issue perhaps a dismissal and a letter of instruction as to what needs to be done in the future and to acknowledge what you've done in the past to make sure it doesn't happen again. We have a very critical election coming up in 2024 in which we are going to be, I'll use the term, target on our back around the country. We're going to be a state that the whole country is going to be looking at. And we need our folks to be at their best. And we know folks are trying very hard, and they're working very hard, and we want to be a collaborative body with our county election boards. But this is a sort of example that I'd like to hear from Floyd County as to what they've done to make sure this doesn't happen again as we approach the 2024 election. I'm not looking to find them necessarily, but I simply want to make sure that certain remedial actions have been taken. And for that reason, Mr. Chairman, I'm going to move to continue this to the next calendar.
Would you also like to take it off of the dismissal, or do you want to leave it on the dismissal, just continue it to the next meeting, or do you want to move it off of the dismissal?
I think it ought to be taken off the dismissal.
And put on a violation so that Floyd County can get notice that they're...
Yeah, so they can get notice, but with the understanding, I'm sort of hinting to Floyd County how to do this. Come to us and tell us how you fixed it, or how you are fixing it, so that in the 24 election, you're going to be dealt with far differently than if you come here, lawyer up, and simply say we didn't do nothing wrong. You're going to have it's going to be a lot rougher ride. But if you come to us and tell us how you already fixed this issue, we're going to be working with you. And it also provides guidance to the other 158 counties as we approach the 24 election. So hopefully I've given enough of a hint to my friends in Floyd County.
So there's been a motion to continue it from this calendar, to move it to the violations calendar and hear it at the next available hearing where it can, or the next available meeting where it can be presented. Assuming the Secretary of State's office is ready and assuming Floyd County is ready, we'll put it on the next available calendar. Is there a second?
Second.
There's a second. Is there any discussion? No discussion. We're ready to vote. All those in favor would say aye.
Aye.
All those opposed would say no. Motion carries. Okay, the next case that I've got pulled out is 2021-085, which is binder number 4. Secretary of State's office.
Yes. The Secretary of State's office received an anonymous complaint alleging a voter who lives in Jonesboro, Georgia, in Clayton County, and voted in Muskogee County during the November 2020 general election. The anonymous complaint alleged that the voter fraud was reported to the Muskogee County Voter Registration Office prior to the runoff and alleged that no verification actions were taken to protect election integrity.
Here's my problem, Mr. Chairman, if I may.
Yeah, you have the floor.
There is a request to dismiss something because there's an allegation, a serious allegation of someone voting twice, and we are being asked to dismiss a case because someone's not cooperating. We shouldn't be dismissing cases because someone's not cooperating, particularly on a serious violation, potential violation such as voting twice. And so I'm going to move to dismiss, I'm going to move to continue this one as well. I would ask my friends, the investigators, to reach out to this person again, and I would also ask that the respondent be called to the next hearing, and let's hear what she has to say, because I don't think that someone not cooperating with you ought to be rewarded with a dismissal.
They sent certified letters and...
I
They
know,
made
no,
no-
no,
oh.
I'm not questioning you guys, I'm questioning the individual who's not cooperating.
There's some, is it coming from the hallway? Would somebody mind just do us a favor and go out and just ask them to keep it down a little bit? Thank you, I appreciate that. Y'all were hearing it too, right? It wasn't just me, okay, all right. Thank you very much, sir. Appreciate your help. Thank you. Thank you. Okay, so there's a motion, there's a motion.
I'd like to ask more information.
Okay, let me get a second first, and we'll do it during discussion, if that's okay.
Right.
There's been a motion to continue it off of the no violations calendar and move it to the violations calendar and hear it at the next available hearing. Is there a second?
Second.
Okay, there's a motion and a second. Now, is there discussion? Dr. Johnston, you have the floor.
So just a question of my colleague. This is a question about double voting or residency?
You're correct, it's residency, I didn't mean, I misspoke. I misspoke, you're correct.
So Mr. Lindsay says that it's a residency question and not double voting. So there's a motion and a second. Further discussion?
Mr. Chairman, I have a question concerning the respondent, Ms. Byrd. Did the investigators know if she received or was sent a precinct card?
Pardon me?
A precinct card? Precinct?
Right.
Not sure. We pulled her DDS and her voter registration in Muskogee County that was dated 10/5 of 2020. I don't know about the precinct card. Or the,
Is there a representative from Muskogee County?
All right, if you'll press the button. Okay, so press it again, please. There you are, I got you. Let's test it, see if we can hear you.
Testing 1, 2, 3.
There we go.
Yes. I'm Nancy Boren. I'm the Director of Elections in Muskogee County. I did respond to the investigator regarding Arania Byrd. Ms. Byrd did register to vote in Muskogee County. We had her voter registration in our county and provided the investigator a copy of that registration. The investigator contacted us at a later date, though, and said that he had actually traveled to Ms. Byrd's residence and it was empty, and that neighbors had attested that her apartment had been empty for some time, and he provided that information to us, at which point we canceled her her voter registration in Muskogee County at that point. Prior to that, though, we also provided to the investigator the documentation that we had where the voter had registered appropriately in Muskogee County. And so she was a registered voter in Muskogee County, but when we were provided with the information that she no longer resided in that apartment, we canceled that registration.
Yep.
Obviously, we cannot verify. We have 200,000 people in Muskogee County, and so, when a voter fills out a form and provides the information they need to provide, especially to the Department of Driver Services, we register that voter.
Yeah, let me be clear. I'm not questioning you guys. It's Ms. Byrd that I'm questioning.
Yeah, Muskogee County is not the respondent. Just wanted to be clear to the people watching.
Oh, I thought Ms. Johnston had requested.
No,
to
no,
have
yeah,
us there,
No.
but we just want to make it clear to the people watching
I
out
just
there
wanna
that
make it clear.
Muskogee County's not in trouble here.
Yeah. Okay, thank you.
It's Ms. Byrd that I have questions about for her lack of cooperation.
But Ms. Bourne, I do have a question.
Sure.
Is there a record that she was sent a precinct card to this address that has an empty apartment?
One has to assume that a precinct card was mailed, as that is normal process. When we enter a voter registration at the county level, that is transmitted to the state level, and a precinct card is printed, sent to the county, and then we mail. Of course, if it's returned to us as undeliverable or no forwarding address, that would be noted in the voter registration record.
And there was no record of that?
I can't confirm, or I don't know, because again, I would have to refer to Jarvis. Typically, it's noted in Jarvis whether or not that return mail is scanned in.
Right. Thank you.
We
So,
appreciate
Mr.
it very much. Thank you.
That's my motion. And let me also state, and this is for our team, it would be helpful to the counties in the future when we list the counties, when we list the case, to make it clear whether or not this is a matter involving the county election board or a private citizen within that county. I think that'll be helpful to them in the future. But that's just simply an administrative part for us.
Yeah, I think that's a good suggestion, that we indicate that the county is the venue of the offense and not the offender.
Yeah.
So we'll be looking at a way to make that more clear in the future for future agendas. That's a good idea. Okay, so we've got a motion to remove it from the no violations calendar, place it on the violations calendar, and continue it to the next available hearing. And I think I got a second on that, but give me another second, just in case. So I've got a motion and a second. Any further discussion? All those in favor say aye.
Aye.
All those opposed would say no. Motion carries. Okay, the next case that I've got pulled out is SB 2022-227. It would be number 10 on your binder. Secretary of State's office.
Yes, SEB 2022-227, Muskogee County buying votes in AB fraud. The Office of the Secretary of State received an anonymous complaint alleging buying votes and absentee ballot fraud in Muskogee County. It is alleged that the Columbus, Georgia Community Warriors Organization president enticed the homeless with food and money to complete mail-in ballots to cast votes for Democratic President Joe Biden. It is also alleged that Community Warriors president, along with his wife, completed ballots casting votes for their adult children who did not live with them. This was said to have been done without their children's knowledge. Mr. and Mrs. Clay told the investigator that they never requested, completed, or submitted absentee ballots for their adult children. Mr. Clay also said that he did not entice homeless individuals with anything for them to complete absentee ballots for President Joe Biden, and he stated that he didn't submit any ballots for homeless individuals. Mrs. Clay told the investigator that the organization, the Community Warriors, does conduct food drives for the homeless, and that although her husband is the president, other people are involved with the operation of the organization. The ElectionNet database indicates that Mr. and Mrs. Clay, 3 children, only one of them voted in the 2020 election. They told the investigator that their youngest child is a freshman in college and they did not vote. Mr. Clay indicated that their oldest child is not eligible to vote. Investigators spoke with the only one of Mr. and Mrs. Clay's 3 children who voted in the 2020 election, and in contradiction to the allegations made, he told the investigator that he completed and submitted his absentee ballot. The election database revealed that he submitted his absentee ballot on 11/3/2020, and that Mrs. Clay mailed in her ballot, which was received on 10/2/2020. There were no names or other identifying information provided for any homeless individuals whom they allegedly enticed into voting for the Democratic President Joe Biden.
Questions from the board?
Thank you. I had you pull this case for a very particular reason, which is the complainant here was anonymous. We have no idea who submitted the complaint, and it was completely unsubstantiated based on the investigation. But I have seen time and time again in recent months a real pressure and attacks against facilitating voting for people who are unhoused. I've seen suggestions that people who are registered at homeless shelters should be challenged and not allowed to remain registered. Making complaints like this appears to me to be an act of intimidation against groups who are serving homeless communities, persons who are unhoused, trying to support them. And if you don't have the courage to provide your name and contact information, if you're making these allegations, I have to question the motives of somebody who's doing that. People who do not have permanent shelter still retain the right to vote. They still retain the right to remain registered. And they retain the right to receive assistance from their community, even if that assistance includes providing absentee ballot applications and using these locations as a mailing address to receive that absentee ballot. And I just wanted to make that point very clear, and this provided me with an opportunity. I don't have any further questions.
Okay, thank you for your comments. Any further comments on this case? Okay, then we'll move, with the board's unanimous consent, we'll move forward to case number 2022-262, tab number 12. Secretary of State's office has the floor.
Secretary of State's office opened this investigation on October 27, 2022, after receiving an inquiry from an individual from the American Constitutional Rights Union regarding potential absentee ballot fraud against vulnerable individuals, including senior voters who are patients in nursing homes or retirement facilities. This individual reported receiving a tip from a Polk County GOP chair, Janet Ross. Ross reported she witnessed an exchange between Polk County election employees and an unknown female who had come to the Polk County Elections Office to obtain paperwork regarding assisting voters who cannot physically fill out their absentee ballots. Ross then contacted the individual, provided them with the information. And the potential violation would be Georgia Code 21-2-385 sub A and 21-2-385B, which covers the procedures for voting by absentee ballot. The investigator reached out to the Polk County Elections Director, Noah Beck, regarding this issue. He requested a statement and the information regarding the female. Beck advised that he would provide the name of the individual. On January 31st, 2023, investigator DeWeese received the name of the unknown female from Polk County Deputy Director Stephen Walker. Walker also clarified that he was not the person that entered Noah Beck's office when Janet Ross was in the meeting. On February 1st, 2023, DeWeese contacted Ellis by phone. Ellis confirmed that she was the person that came to Polk County Elections to obtain the information needed to assist the patients in her care, and that female's name is Ryan Ellis. Ellis stated she was asked by her employer to assist the patients that could not fill out the absentee ballots. Ellis confirmed that she did take the oath provided by the election staff. He asked her about the steps she takes to determine if the patient is mentally competent to cast a ballot. Ellis advised that she conducts a brief interview assessment with the patients she helps. Ellis was asked about the patients in the memory care unit. Ellis advised that if the patient is not capable of understanding or does not do well on the assessment, then she does not proceed with filling out the ballot. Ellis provided the list of 13 names she assisted filling out ballots and registration forms. On February 6th, Investigator DeWeese received a written statement from Stephanie Welch confirming she was the person that provided Ellis with the oath and instructions for transporting absentee ballots. On February 17, 2023, Investigator DeWeese received Noah Ballott's written statement and the absentee applications and oath envelopes for the ballots that Ellis assisted with. 12 of the 13 absentee ballot oaths were provided. One voter did not return a ballot. Investigator DeWeese reviewed the applications and envelopes and did not see any violations. The investigation revealed that a third party, alleged a female, later determined to be Ryan Ellis, unlawfully assisted nursing home residents to complete the absentee ballots. That charge was unsubstantiated. The respondent is a recognized caregiver employed at the Rockmart Health and Rehabilitation Center as a social worker and took the prescribed oath required by law. Investigator DeWeese confirmed with John Wilson, the administrator for that facility, that the responsibility of assisting patients with absentee ballots was Ellis's. Ellis complied with Polk County Elections Office legal requirements to be a temporary absentee ballot clerk. DeWeese reviewed the applications and oath envelopes that Ellis assisted with, and no violations were discovered. It should also be noted that the Secretary of State's Investigation Division has not received any complaints from any of the electors or their family members. So ultimately, there was no evidence to support a violation of the Georgia codes listed.
Comments or questions from the board?
Yes, a question for the investigator. Were all 13 electors contacted and interviewed to confirm their consent for assistance?
No, they weren't interviewed.
As my colleague just spoken on the previous case, I think we need to take extra steps to protect the right to vote. But we also need to be very vigilant that the voters are protected. And I would suggest, just as a recommendation to counties, that they use two-member teams or bipartisan teams to go to nursing homes, or homeless shelters where the call is made for assistance. But I would make a motion that we continue this case and ask the investigators to interview the 13 electors and make sure that they gave their consent for the absentee ballot request and for the vote.
Okay, there's a motion. Is there a second? Hearing no second, the motion does not carry. It fails for lack of a second. Are there any other motions?
Let me preface why I have not seconded this as
Mr.
opposed to
Lindsay
some
has
other
the floor.
cases. In that, in this particular situation, we have a complainant who did not actually witness the voting taking place, but simply witness someone making the applications. If there was a situation in which a complainant actually firsthand saw this taking place and questioned whether or not someone was able to do so by their own free will, I would most certainly be seconding it. But since it was simply, the complainant was simply someone who saw someone exercising what is legal underneath Georgia law in terms of a caregiver, that's not enough for me. So that's why I have not seconded it. I will also add that, this is something maybe perhaps for the legislature to take up in terms of who should be assisting folks in these homes, particularly if a individual has indicated that they would like only a certain family member to assist them. But that's something for the legislature to take up. There's no evidence that this particular individual violated the law. That's why I have not seconded it.
Okay, with that, so that one stays on the calendar. So we are now have been through all the cases that the board members have pulled. I've got 2 and 4 being continued off of the calendar and the remaining cases staying on the calendar. So if there a motion by the board to dismiss the remainder of the cases 2 through 16 with the exceptions of 2 and 4 in your binder.
So moved.
There's a motion. Is there a second?
Second.
Has there been a motion and a second? Any discussion? Oh, okay, let me give you the case numbers. I'm sorry. I was using binder numbers, so let me do the case numbers. Okay, here you go. Thank you for bringing that up. That was good. 2020-086 has been pulled and continued and moved to a different calendar, and 2021-085 has been continued and moved to a different calendar. And then the remainder of the cases shown on the agenda as recommended to be dismissed have a motion to be dismissed. And it's been seconded. Yeah, we don't take. Hang on, let me. Hang on just a second, let me press your microphone. If you'll press the button in front of you that says talk or something. I got you. Can you first identify yourself for us?
My name is Jeannie Seaver. I'm from Chatham County, and I have a case. It's basically the second one on the list, SEB 2021-12, absentee ballot processing. I was told by your staff that was, that I would be notified and have an opportunity to speak when this case is being spoken upon.
Yeah, I regret that advice was in error. You're the complainant in the case?
Yes.
Traditionally, or the board has adopted a policy recently since last December last year that we're trying to clear cases off the calendar and move through them quickly. And one of the hard choices that the board was forced to make is the decision to whether or not to continue a policy of allowing the complainants to present on the case or not. And so that's just one of the tough choices that the board had to make, was that the complainants do not traditionally speak on the matters. And so it's the board's investigation that's being heard. So I regret that you were given incorrect information. But
I was told that I would give an opportunity. Your staff member right there told me so, sir. And Mr. Miller also told me that I would have an opportunity to speak when my case came up.
Yeah. Okay. Okay.
That being said, Mr. Chairman, since she
Hang on. Go ahead.
since she did come, since she was told, even though it was a mistake, if
I've got it in an
Hang
email
on.
too, sir.
hold on. I'm with you here. That's fine, but she drove all the way from Chatham County.
Okay.
For that reason, because she was incorrectly told that she would have an opportunity to speak, she came all the way from Chatham County. I would ask that she be given a few minutes to speak.
The board controls its agenda, and the board member has made a unanimous consent request.
Yes, sir.
That you be allowed to speak. Would 3-4 minutes suit?
Is the case going to be read out loud? It should be read out loud what I'm responding to, my complaint.
Well, what the board member has,
For that reason, Your Honor, Mr. Chairman, I will pull number 3 as well. Let's hear it.
okay, so there's been a request by the board member to pull case number 2021-012, unanimous consent motion unless there's objection, so ordered. Okay, so case number 2021-012, Secretary of State has the floor.
On January 5th, 2021, investigator Chuck Miller was forwarded a complaint involving the Chatham County Board of Elections and alleged improper processing of absentee ballots. This complaint alleges that improper processing of absentee ballots by the Chatham County Registrar's Office while they were renting out office space at the Savannah Convention Center. The Convention Center security cameras captured video footage of Chatham County Registrar's Office workers, volunteers, and staff entering and exiting the building at various times. It also depicted county as well as personal vehicles parked on the premises and workers loading and unloading these vehicles with various supplies as well as absentee ballots. The investigator viewed footage a total of 3 times with Ronnie Hickman, Savannah Convention Center's Director of Operations, along with Chatham County Registrar Sabrina German, Russell Roden, CEO of Tatno Ballot Solutions, along with Chatham County Registrar's Office staff. Footage depicted staff members, workers, and unidentified persons entering and exiting the Savannah Convention Center building with supplies, mail, as well as equipment. Later, the camera security video crashed and all the bookmarked video footage of inside entrance areas were lost. The registrar, along with her staff and the CEO of the ballot printing company, denied witnessing or being involved in any activity in violation of the state election code. The complainant's original allegation was that she saw an employee loading a box of absentee ballots and leaving other ballots in their vehicle unattended. When asked by the investigator how she knew the items were absentee ballots, she admitted that she did not know and that it was speculation on her part. Investigator Chuck Miller spoke with the complainant, Janee Seaver, concerning the allegations, and she stated the following. She did not know for sure the contents of the container were absentee ballots. It was an assumption since the elections office was working out of the facility. She watched the video and felt it needed to be brought to someone's attention. And her final statement was, she honestly did not know for sure, but there seemed to be much going on. So those were their statements when I had the investigator follow up to find out when we got this complaint, well, how did she know if she was viewing that they were absentee ballots, and this was the statement that was obtained.
Questions for the investigator from the board?
Can I go ahead?
Okay. All right, so I still have a unanimous consent motion to provide the complainant 3 minutes. With that objection, so ordered. So let me make sure your mic's on. And you've got 3 minutes.
Thank you very much, Mr. Chairman and the board, for allowing me an opportunity to speak. I am from Chatham County. We're one of the few counties that not only has a Board of Elections, but we have a Board of Registrars. They're totally 2 separate departments. The Board of Registrars contracted an off-site facility to process ballots. The report even stated that they had shown video, they had seen video of ballots going in and out. There, for an example, there was a gentleman that was walking out. He put ballots right down in the main lobby area, walked out to his car, took another box there, shut the trunk of the car. You know how you can tell on a video whether they click or not that it's locked? Never was done. Came back, picked up the other box, and went it back there. So not only was it left unsupervised in the lobby area, but also in the car. Yes, we do have, sometimes we have the city, the county that picks them up. But if you look at these videos, and like you said, they've disappeared now. So I do still have some on my phone that I would love to show you sometime. But I am telling you, I've been a poll watcher. I've been active in our community. We have a lot of complaints in Chatham County on what's going on, and we never really get a voice. I've always been about the right thing to do. So I put myself out there, came up here to report to you what I thought and felt was truly wrong, and that it should be investigated. Now, I watched some meetings a couple of months ago that basically this board requested a report from the Chatham County Board of Elections or Board of Registers, a whole list of complaints to be presented to the board. I don't know if those complaints have been provided. I know you asked for them, but I don't know if they have. It's very disappointing that Chatham County is not here to speak or maybe to explain. I have the pictures. I'll show each one of you. There's something not right going on around there. And it's like, this is not personal. As we all know, there is a major issue in Georgia, and they are not feeling confident with the votes, their votes counting. When I saw this, I felt the need to report it. I am begging you to please take under consideration to look further into this investigation and not dismiss it. There were things going on that you didn't hear everything. And I just honestly request that. And like I said, we must do every effort to make sure that our people that we pay our money to, make sure they follow custody of ballots and protocols. And I'm telling you, they were not followed here, and I just think that there could have been some more investigation. And to say that the tapes just disappeared off the network is just totally unacceptable to me. Thank you so much for your time. I really, really appreciate it.
Thank you for your comments. Turn
I
off.
may ask a question to the investigator. Did we talk to the folks in Chatham County about you know, in terms of maintaining control of the absentee ballots, which you talked about in particular with the car in and out?
Yes, we interviewed staff, personnel, etc. And I actually had the investigator go back and talk to Ms. Seaver when I read this complaint, because it was a pretty thorough job done as far as who he talked to. He sat down, he actually watched this video before it crashed. He watched it with the representatives, some of the leadership from Chatham County, and then later during COVID, I guess, is when it went down. So he actually saw the video himself, the investigator did. And I had him follow up to find out, okay, she's making this allegation. How did she know they were absentee ballots? And what I read was that she didn't know. She was speculating. This is the statement that she gave the investigator, because I wanted to make sure if she said she saw absentee ballots, then that's what she saw. But on a follow-up interview, she said that she was speculating, and she didn't know what they were. She saw individuals loading up or having things in their vehicle, but she couldn't say for sure that they were absentee ballots. So I think we did a pretty thorough job in investigating this and even following back up with the complainant regarding her allegations.
With regard to the investigator's observation of the tape, of the video, did he observe that certain items were not being, regardless of what was in them, certain boxes were not being attended to at all times, that was going in and out?
I mean,
He may not have known what was in the box, but did he observe what she's speaking of in terms of boxes not being attended to at all times? You understand what I'm questioning? There was a specific, she raised one specific point among others, that somebody had boxes, was carrying them in, put them down, left them unattended, went back to pick up another box in the trunk that was unattended, and then carried both in. I'm just asking whether or not that was on the tape that he saw.
there were so many hours of video that he saw people, because they were using that as another location. So he saw individuals with paper, with all types of supplies. When he interviewed people, that's what they said, that they were bringing supplies, paper, you name it. And so it was so voluminous as far as the amount of footage that he saw that he couldn't determine specifically, you know, what she was referring to, because there were so many hours of video that were part of what he reviewed.
Can I make one comment to that?
Not yet. Mr. Lindsay has the floor.
Yeah, well, if you can, just not to speak, just real specific to that.
Say is I got a phone call about 2 weeks ago from the Secretary of State's office asking me, did I know what was in those boxes? I was surprised by it, because don't you think Chatham County Board of Registers should be telling him what's in those boxes and not me? I just put it up there for them to investigate. I thought it was very unfair that I got a phone call a couple days when I've been waiting for almost 3 years for this case.
I understand. I'm sticking to what you know. I don't mean to cut you off, just want to try to get to that point. I understand. I don't mean to be dismissive.
Ms. Gazelle?
Yes,
Board Member Gazelle?
One note that I had made on this report was that there were no sign-in sheets, no logs, and I don't think that is something that has been required in the past, but I think that couple of points. A lot of counties, a lot of large counties are having to use ancillary facilities. And I think it would behoove us as a board to look at the rules and see if there should be a mandate to have sign-in sheets for any facility that is processing ballots, whether they're voted or unvoted ballots, to have people, if there is a building that has ballots and it is not the election office, I think that should be a standard practice and not just a best practice, but a required one. So for the record, I think that as we look at rulemaking, we can add that so that we have a solid record of exactly who is in a building and in a room with a ballot. And I think this is a good case. There was no violation on that because there's no rule, but I think there should be.
But there is a rule in terms of maintaining control of the ballots,
Yes.
even though there's, how you do so isn't.
This just brings into question the whole issue of how to handle ballots. And dual control is absolutely necessary. Documentation is absolutely necessary. And complete chain of custody from the moment the ballot is printed until the ballot is all the way through process and stored in the clerk of the court. So if we cannot ensure that, then we have a problem, and we have to have documentation. Every time that ballot is touched or moved or conveyed or stored or packed, it has to be witnessed with a team, and I would prefer a bipartisan team, and it needs to be documented.
At this time, it's been removed for discussion, but as to its disposition, we're ready for a motion on this particular case. And everybody check me, 2021-012 is what we're on, right?
Yes,
Okay.
Mr. Chairman. Mr. Chairman, I would move to continue. I'd like to hear from Chatham County, and I do understand my fellow board members' admonition regarding the clarity in terms of the rules, but the rules do require maintaining control, and it does appear that there was a certain amount of chaos going on. I haven't seen any evidence of nefarious activity, but certainly chaos was going on, or at least a small level of chaos going on. And similar to what I said with Floyd County, I'd like to hear from Chatham County that they've got this thing under control as we go into the '24 election. And for that reason, Mr. Chairman, I would move to continue this matter. And I think my investigators did a good job. I'm not questioning you guys, but I would like to hear from Chatham County as to how we're going to be able to maintain better control over the ballots, particularly as we go into the '24 election.
Okay.
And for that reason, I would move to continue.
And move it to a violations calendar? as
Yes.
well? Okay, so there's been a motion to continue the case, 2021-012, and continue it and move it to the violations calendar. Will it be presented at the next available hearing when it's ready? Is there a second?
A second.
There's been a motion and a second. Discussion? No discussion. All those in favor would say aye.
Aye.
All those opposed would say no. The motion carries.
And let me also, no. Let me also say to folks in Chatham County who we've talked with in the past, coming to us in December and explaining how we're going to have better control and how, quite frankly, as my fellow board member mentioned, we are looking at rules that we will be implementing or proposing at the next meeting, and this would certainly be one of the, we're adding to the list every day. And having not just Chatham, but the other board folks out here on how to maintain better security and what kind of rules would be practicable would be very helpful to us, and we look forward to your input. Thank you, Mr. Chairman.
Okay, so the case number 2020-086 has been continued. 2021-012 has been continued. 2021-085 has been continued. And the remainder of the cases that are now 5 through 16 in your binders are recommended to be dismissed. If there is a motion in that regard, I'm ready to hear it.
So moved, Mr. Chairman.
There's been a motion. Is there a second?
Second.
There's been a motion and a second. Is there discussion? Hearing no discussion, we're ready to vote. All those in favor would say aye.
Aye.
All those opposed would say no. Motion carries. We'll now move to violation cases. First case is 2018-110. Secretary of State has the floor.
Tab 17.
I'm sorry?
Everybody there?
Tab 17, correct. Yes, sir. Please.
Okay. The Secretary of State's office received 2 complaints reporting alleged ballot issues in the November 6, 2018 general election in Coweta County. Complaint number 1 is regarding Brittany Bell, who reported she went to vote in Coweta County on election day around 6:45 p.m. She went to the firehouse polling place, but her assigned polling place was crossroad was somewhere else. Ms. Bell did not have her ID with her. The poll worker told her that she was at the wrong precinct. She requested a provisional ballot, but the poll worker did not give her one. Mrs. Bell stated she eventually left without voting. And it also was at the end of the day, and there was no way she could get to the correct precinct She should have been offered a provisional ballot, ultimately. Complaint number 2. The Coweta County Election Supervisor, Jane Scoggins, reported voter Ethelene Watson voted twice in the November 6, 2018 general election. Mrs. Watson submitted an absentee ballot and then later voted on election day. She apparently, when she showed up, apparently she submitted her envelope saying she was going to cancel her absentee ballot, and then she was allowed to vote a second time. So regarding complaint number 1, the complainant was not able to vote based on a wrong interpretation by a poll manager, Sarah Brooks. When Mrs. Brooks was interviewed by the investigator, she indicated that if someone does not have identification, she does not offer them a provisional ballot. That is obviously incorrect, and she should have received one, and this is a violation of OCGA 21-2-418A that deals with provisional ballots. So that's complaint number 1. Complaint number 2, Ethelene Watson voted twice in the same election when she voted by absentee ballot, which was received on October 12, 2018. She also went and voted a second time on election day, November 6, 2018. There is evidence to suggest that she voted twice in the same election, although during an interview she denies that. Mrs. Watson is, I know that's a question that often comes up. She's 84 years of age. When this incident happened, she was 79. Her actions are a violation of OCGA 21-2-572, repeat voting in the same primary or election. A subsequent violation based on Mrs. Watson's double voting is the fact that Coweta County election workers should have checked the Board of Registers before allowing Mrs. Watson to vote. The fact that they did not is a violation of SCB Rule 183-114.09 regarding voting absentee ballots. The potential violator is Jane Scoggins, a former election supervisor of the Coweta County Board of Elections. And that is it.
Questions from the board for the investigator?
Were you able to interview Ms. Watson?
Yes, yes. She denies. She denied that she voted that second time on election day. But,
So
I mean,
she
there's evidence to
denies the
suggest.
in-person. She denies the in-person vote
Yes.
and not the absentee vote.
Yes, she denies the in-person.
And you have the voter certificate and,
Yes, we were able to confirm that she did in fact vote that second time.
thank you. I want to just point out that not only is and this is for the benefit of anybody watching, not only is the denial of a provisional ballot a violation of Georgia state law, it is also a violation of federal law. 52 USC 21082 requires that people requesting a provisional ballot be offered one under state law. So just putting that out there.
Is any other questions from members of the board for the investigator? Is Ms. Watson here or anybody on her behalf? Ms. Watson? Is anybody here from Coweta County? Coweta County? Okay. If you'll press your button on your microphone. I got you. Let's test and see if you're
Testing.
on. Gotcha.
Working. All right, I'll stand up. I'm kind of short. My name is Nathan Lee. I represent the Board of Elections in Coweta County. Jane Scoggins with me. She's the former, they called it election supervisor back then. And she is retired in 2022. She's on the election board still. I have Ashley Gay. We now call her the election director. She's the current election director. Would you like me to address both of these in one while I stand? Is that okay? The first
without
one
objection, go ahead.
With respect to Miss Bell, Sarah Brooks was our poll worker. She's not here today. She's had to note she can't help out anymore. Her husband is ill. She has to stay at home with him, so she's not here today, nor will, she's unfortunately not going to be able to help us with elections. She apologizes she can't be here, but she had to do that. She did remember getting a phone call from an investigator. She reported it to Ms. Scoggins. They made an appointment to come meet at the elections office with Ms. Gay. The investigator called, said he had a family emergency, had to cancel, and that was the last thing. Somebody called back and said, called Ms. Brooks and said the matter had been worked out. Was it you or Ms. Brooks? Ms. Brooks and said it had been worked out. Ms. Brooks does not remember Ms. Bell, does not remember talking to Ms. Bell. The only remembers talking to the investigator to arrange the meeting at the office, and the second phone call. If you look at the report, the investigator also indicates he spoke to Ms. Scoggins, who said you should be given a provisional ballot. Ms. Scoggins also does not recall ever speaking to the investigator, only going to the meeting where he was not able to attend. That's all I have on that one, unless the board has any questions.
Just whether or not the woman, I'm sorry, was the voter able to somehow vote that day? Or not?
Was the voter able to vote?
Like I said, we don't know. No one has any recollection of this incident ever even happening. That's the thing. They don't even recall somebody saying, "I don't have my ID."
That's fine. No, I understand that, but you know, there's a record of who votes.
Oh, I don't know. Do we know? I'm sorry. I do not have that information.
Did anyone check to see whether or not Ms. Bell actually figured out a way to vote that day?
I'm sorry. I don't have that answer, Mr. Lindsay.
Questions? Other questions from the board?
Have you had an opportunity to review your training of poll workers, poll managers on issuance of provisional
Absolutely,
ballots?
and they're all trained to give them a ballot. That's why, you know, we would have disputed this had we given the opportunity. So, yes. And the report says Ms. Scoggins told the investigator that's the procedure, but she has no recollection of ever speaking to him either. So. But we're here, we will do whatever the board.
How easy is it to check and see whether or not Ms. Bell actually voted?
Can somebody
Can I give
quickly,
the mic to one of them?
Yeah.
technology,
How quickly can you do so, meaning can you do so today?
like right now?
She's checking right
Awesome.
now.
All right, I may
Technology.
continue this
I would
case to
think-
find out.
I would think that if she was there at 6:45 and wanted a provisional ballot, that she would not have been able to vote.
Yeah.
Oh, I'm sorry, I wasn't there, and I
I
didn't know
understand that, but like I
anything.
said, it would be helpful to me to know whether or not the woman figured out another way to vote that day.
Your-
I'd like to know whether or not the woman voted that day.
Your colleague is hard at work, I see, so we'll give her a second. Is there any other questions while she's working on that, or are there any other questions of the board so we can keep moving? Other questions from the board? Other questions from the board?
Well, in regards to the double voting,
Yes, we're ready to address that one.
is there, yeah, go ahead.
Yeah, so that's actually one, Ms. Scoggins was involved with that. She's actually the one that reported it, and they feel very firmly that it was an intentional double vote. I mean, the packet, the envelope came, I mean, you can speak to her if you'd like, she was certainly glad to answer any questions. She came in, we believe it was an intentional effort to mislead and to double vote, which is why Ms. Scoggins reported it to the state board, and Ms. Scoggins is actually, if you don't mind if she sits, she's had a couple, 5, she's being modest, 5 surgeries.
Yeah.
She got up here today, but if she could sit to
Yeah,
address the
absolutely.
board, she's prepared a statement about this that she'd just
Okay,
like to address.
Your microphone's on. You can, let's test it out, see if we can hear you.
Can you hear me?
Yep.
Okay. On the day that, on November 6, 2018, Ethelene Watson appeared at the polls to vote in person. She took the ballot that appeared to be the ballot she received in the mail. It was still sealed, and since she was listed as voting, as being issued a ballot in absentee status on the express poll, the express poll operator referred Ms. Watson to the poll manager. The standard procedure would be for the poll manager to call voter registration and have the absentee ballot canceled before issuing a voter card. The next day, after the election, Ashley Gay, the Assistant Elections Director, was working in ENET and noticed that Ms. Watson's ballot had been accepted, and yet her unopened ballot, unopened mail ballot had been surrendered at the polls. She called and told me. I asked Ms. Gay to check that surrendered ballot and see what was going on. When she opened the white sealed envelope, she found several folded papers inside, so that it appeared to have the ballot intact. I notified the Secretary of State's office and sent copies of the white envelope with copies of what was in it. I sent her registration card, her ballot application, the yellow envelope, a copy of her driver's license, and the election day numbered list showing where she had gone in and filled out the paperwork to vote. In my 20 years of working elections, I've always strived for accurate, secure, fair, transparent elections. So when this happened, I was disturbed, to say the least, and reported it to the proper authorities, because I think that's the right thing to do. After this, in Coweta County, we changed our policy. When someone is listed in absentee status on the poll pad, or back then the express poll, they no longer have to notify the poll manager. They are referred to a separate station. We've set up a station, and at that station, then the person would go over there, they would call voter registration, they would have the ballot canceled in voter registration, and then have a piece of paper. It would say who canceled the ballot, and the reason they canceled the ballot, and by whom, and the reason, and then they would give that piece of paper to the person on the poll pad. They would then remove the absentee voter status and issue a voter card. I hate that it happened. If I could change it, I would.
Yes. Thank you for your comments. Questions from the board? Questions for the board?
Question.
Okay.
What is your process with spoiling ballots that are returned, absentee ballots that are returned to the polling place?
We use the spoiled absentee ballot form that the state has. That's what we set up the separate station to do. So if it's a spoiled or a canceled ballot,
right
now instead of just notifying the poll manager, which would have been the procedure, you would actually go to a separate station, so the poll manager has this person, that's what they do, that's what they handle.
Do you actually mark on the ballot itself, spoiled or canceled, or
yes, you do.
a big X? You do.
You're right, spoiled or canceled. Like in the, if it's an absentee ballot, it would be canceled. So you would write canceled across the envelope.
Thank you.
And her ballot was marked canceled on the one she surrendered. It just didn't have the ballot in it.
So the envelope was marked canceled?
Yes, the envelope, it was marked canceled.
But the ballot was not in there?
No, but the poll workers thought the ballot was in there because it felt like the ballot was in there. And it was sealed. Even when we looked at it at our office, it was hard to believe that the ballot had ever been opened. But once we opened it, because like I told Ashley, how could she surrender her ballot and you counted her ballot, her absentee ballot? That's when we opened it and discovered the folded papers.
Thank you.
Other comments from the board? Other questions from the board?
Yeah, I'm trying to figure out what happened to the ballot.
Pardon?
Do you know what happened? Did the absentee ballot get counted? Do you know?
Yes, it did get counted.
It was mailed in, counted.
Oh, so it was mailed in separately?
But because what happens when you get the ballot, it's mailed back in the yellow envelope.
Hold the mic a little bit closer, please. There you go.
When you mail in your ballot, you mail in that yellow envelope with your ballot in it.
So
But she had sealed the white envelope that she received in the mail. It appeared that the one she received in the mail with the yellow envelope and the ballot and everything, it appeared that it was still inside.
Okay, so if I understand correctly, she mailed separately the absentee ballot, but she showed up at the polls with what purported to be the absentee ballot. That was marked canceled. That's why she was allowed to vote.
Correct.
All right.
Questions, comments from the,
Mr. Chairman, we still don't have the, we're doing our best, but we can't find out if she's voted.
I appreciate that. I appreciate your effort. Thank you very much. Member Gazelle?
I would move that we refer Ms. Watson to the Attorney General's office.
Second.
There's been a motion and a second that Ms. Watson be referred to the Attorney General's office. Is there discussion? We're ready to vote. All those in favor would say aye.
Aye.
All those opposed would say no. Motion,
I would also
motion
move that
carries.
in regards to the Ethelyn Watson matter, that the allegations against Coweta County be dismissed.
What?
Be dismissed.
There's been a motion to dismiss the charge against Coweta County. Is there a second?
Second.
Is there discussion? And I'll take this opportunity to discuss in that I've always been troubled when we have these situations where the county self-reports an issue and says, this person tricked us and did something they shouldn't do. And in the past, not this board, but in the past, the reward has been, okay, we're going to charge you. And that always struck me as being very unfair. And so, and there are times when the county is culpable and they self-report, and I don't think we should excuse that, but where the county got tricked and they tried their best and somebody acting improperly just tricked them, I don't think the county should be held accountable for that. So I join in the motion and just took extra time to comment on that, to let my views on that be heard. So there's been a motion and a second. Any further discussion? Then we're ready to vote. All in favor of the motion to dismiss Coweta County, say aye.
Aye.
All those opposed would say no. Motion carries. We'll move on to the next case. It's tab number 18 in your
Still
book.
waiting on
Oops,
complaint
sorry.
number 1.
Yes.
Sorry. Point of order.
Still waiting on figuring out what to do with complaint number 1.
Okay, so complaint number 1 is still pending. So let's take a look at that.
That is the provisional ballot issue.
Okay.
So let me ask my friends in Coweta County, is there any question as to what Sarah Brooks said in regards to her understanding that if you didn't have an ID, you couldn't be given a provisional? Is there any question as to the accuracy of that?
I'm sorry, Mr. Lindsay, I'm having a hard time hearing.
Is there any question as to, in terms of the investigation, as to Sarah Brooks's comments that if the voter did not present ID to vote, then they would not be issued a ballot?
She says I would not have said that because I was not trained to say that. But again, she says I have no recollection of any of this happening or talking to her. So it's a he said, she said, I guess.
Well, no, it's my investigator said.
I thought the question was from me. I apologize.
No, I understand what you were going to. Let me ask you this, to my investigator. Who interviewed Ms. Brooks?
That would have been Investigator Monroe, Kelly Monroe
Yeah.
from Macon.
And she filled out her report saying that Sarah Brooks told the investigator the voter did not present an ID to vote, then they would not be issued a ballot, correct?
Yes.
All right. All right, I'm gonna make a motion to split the baby here, because it appears that Coweta County has been given proper instructions, but there's a question as to whether or not Ms. Brooks followed those instructions. And I'm gonna leave it to the Attorney General to figure that one out. And so I would move to dismiss regarding count 1, Coweta County, but move to, in the same motion, move to refer the matter regarding Sarah Brooks to the Attorney General's office, and let's see if they can figure this out.
Motion to dismiss Coweta County, but to transfer Sarah Brooks's case over to the Attorney General for processing. Is there a second?
Second.
There's a second. There's been a motion and a second. Is there discussion?
Only this, that anytime it appears that a voter has been denied the opportunity to cast a valid ballot, it is a very serious issue.
Yeah.
And that it's not to say that individual poll managers should necessarily be punished as much as we need to be held accountable and perhaps no longer serving as a poll manager would be a solution that would be acceptable through the Attorney General's office.
Thank you for your comment. So there's been a motion and a second. Any further discussion? All those in favor would say aye.
Aye.
All those opposed would say no. Motion carries. I'm gonna do something a little bit unusual here and ask the board's unanimous consent for it. And that is, if there are cases with attorneys representing the respondent, could you stand and let us see how many cases we have with attorneys? Okay, we got three. I'd ask unanimous, and the reason why the other respondents are like, well, why do I have to wait? Well, these cases with attorneys, they're paying attorneys by the hour, and so there's an additional punishment that I'd like to alleviate if we can. So I'd like the board's unanimous consent if we could take the attorney cases a little bit out of order. I'm sorry?
Why do we even have an agenda? If we're gonna skip around and give people preferential treatment, why do you even put this on the agenda?
Yeah, I appreciate your comments. The reason is that the board controls the agenda.
And if the board, which,
Yeah, so there's been a,
So now we get to the back of the line.
well, yeah, so thank you for your comment. I appreciate it. All right, so the Judge Levinson, if you would give me your case number, please. Give it to me again. 158. I see it's number 25 on the agenda. Okay, next case.
Hi, yes, Mr. Chair, Bennett Ryan, I'm at DeKalb County. We're here on SEB cases 2020-029 and 2020-043.
Okay, give it to me again.
That is SEB case 2020-029
Okay,
and 2020-043.
okay, great, thank you. Okay,
Ann Brumbaugh again on behalf of the Sheriff of the County. It's SCB 2022-135. It is at position 27.
135, okay, great. Okay, I'm asking unanimous consent of the board that we take, give me your case again, Judge Levinson, sorry. 85, 085, 185? 158, I got it. I'm going to ask unanimous consent of the board that we proceed now with case number 2021158. Without objection, so ordered. Secretary of State's office, can y'all juggle a little bit and accommodate?
what's our tab?
158 is tab number 25. Tab number 25. I appreciate you indulging me, sir. Thank you. I appreciate it. Tab number 25.
Yeah, I got it. Okay. This complaint, sorry. The complaint email contains a chain where the former SOS chief advised Dr. Brian Harris that his company was in violation of 21-570 for posting about a chance to win World Series tickets for presenting an I voted sticker. In the chain, Dr. Harris advised that he had removed the posting from Facebook. The U.S. Med Clinic made a post on Facebook.com which offered a free pair of Braves World Series tickets for Saturday at 8 p.m., 10/30/2021. The flyer gave the following instructions. Like and comment on this post with a picture of you and an I voted sticker or a picture of your candidate's yard sign. Share this post on your page and tag a deserving couple. His legal defense team advised that his intention was not to commit any crimes, and he was allowed to do so by the Georgia Government Transparency and Campaign Finance Commission. A subsequent interview with the attorney who spoke with Dr. Harris advised that he was advising Dr. Harris that his actions would not be connected to his campaign and not in violation of any of their rules. He advised that he was not advising him regarding any other Georgia laws as they were not in his purview. It was noted that Dr. Harris was advised by the former chief that he would receive a letter of instruction over the matter.
Any questions for the investigator from the board?
So do I understand correctly that Dr. Harris was actually on the ballot for the election that this was referring to as a candidate?
I believe so. I believe he was. It doesn't say it in this report. I'd have to pull up the case file. That's what it was alluded to by the other attorney who said that he was not connected to his personal campaign. That's what he was advising of, not about the
Thank you. Well, perhaps
OCGA.
counsel can address the question.
Yeah. Other questions from the board? Other questions from the board? Mr. Kirk, if I could draft you to shut that door, please, if you wouldn't mind, if you'd do us a favor, I'd appreciate it. Thank you. Other questions from the board for the investigator? Okay, Judge Levinson, floor is yours. Thank you.
You hear me all right?
I got you.
First, thank you. I'm Lewis Levinson, represent Dr. Brent Harris for the complaint identifies as Brian Harris. That's just got to be a typographical mistake. We don't assert that as any defect. I just wanted to clear that up for the record. Dr. Brent Harris is a physician, licensed practice medicine in Carrollton, has been for some time. He, in advance of the social media post that MedClinic put up, which I'll talk about separately, we assert, and I think it's referenced in the investigator's report, that he contacted Mr. Cusack, who is counsel for the Georgia Government Transparency and Campaign Finance Commission, for advance approval, being untutored in the ways of this, his being his first campaign, was told that what he was proposing to do was acceptable. I would jump ahead and say that as soon as he was advised there was a problem and a complaint, within hours, the media post was taken down. And I don't think that's a matter of dispute with the report of the investigator. What I think is interesting and perhaps hyper-technical is that what the social media post offered was free World Series tickets in exchange for posting a photo of having a sticker on that says, "I voted," or a photo that shows any yard sign of any kind. And specifically with respect to the statute that proscribes giving or receiving, offering to give or receive, or participating in giving or receiving of money or gifts for registering as a voter, voting or voting for a particular candidate. I don't believe that his post, however misguided it may have been upon the advice of someone, solicited that specifically. All it did was get you or you're eligible, I should say, to win World Series tickets if you post a photograph of yourself with an I voted sticker on, which doesn't necessarily mean you voted, or a photo of anyone's yard sign. Cutting to the chase, we're, to the extent that he acknowledged that this was arguably incorrect when notified and took it down within hours, we'll accept, if the board would agree, a similar letter of admonition similar to the cases that you've heard earlier today. And I believe the facts here are less related to giving or receiving consideration under this report than in the previous cases. Thank you.
Questions for the board, for council?
Slightly different situation than the previous, but let me ask you this. In terms of precedent, and I do appreciate the fact that he took it down when he was advised, so, but what did we do in the previous case? In the last two, there was a raffle.
Letter of instruction, dismiss with letter of instruction.
Okay.
Raffle?
We talked about
The raffle, we referred to the Attorney General's office with the former Attorney General representing the client.
No, the raffle tickets for the rifle got sent to the Attorney General's office. You remember the rifle case?
Yep.
May I answer your question?
Sure, Counsel.
Mr. Lindsay's question, I was referring to the case involving the respondent, Jesse Blankenship, which was your case number ending in 133, where there was
the gas money.
a
Gas money.
presentation,
Yeah.
at least an allegation, that, quote, gas money was offered to voters that would need assistance getting to the polls. That was the reference I was making.
Yeah, I mean, that was a little bit more of a narrow case, because all she was trying to do was make it easier for someone to get to a polls, as opposed to rewarding someone for voting. So I'm trying to make sure that we stay within our precedent that we've had in previous cases. That's why I'm asking the question.
If I may, I don't mean to argue, but
No, you're not arguing.
But I don't think there was specific.
Yeah.
Even the report of the investigator does not reflect there was solicitation to vote or a solicitation to assist anyone for voting for a particular candidate.
No, I wasn't questioning that. I wasn't questioning someone was trying to buy a vote.
Yeah.
Okay.
Well, and just to complete the reference to the rifle case, that case, the respondent was asked, did you do something wrong? Was that ill-advised? And he said no. And I didn't do anything wrong. I might do I don't know if he said I might do it again, but he certainly gave.
Let me ask you this. Will you do it again? I want to hear from your client. Will you do it again? No, sir. All right, that's a good answer.
My caution is this: candidates have to be held to a higher standard than just members of the general public. Candidates have a vested interest in increasing turnout, and so that's my caution in this case. We've got somebody who had a reason, and I've been a candidate myself. I understand, but I have the benefit of also a legal degree and specialty in election law, so it's not quite the same.
No, it's not quite the same, but the fact that he was given certain advice.
Yes.
That was incorrect, and when he was given correct advice, he immediately took it down. That weighs on me.
Yes.
Well, and the Blankenship case, we found, we dismissed it with a letter of instruction, but one of the things that the board has done traditionally is to find a technical violation and issue a letter of instruction as a remedy the board frequently uses as well.
And I would move that would be a solution. We do not refer this to the Attorney General's office. I don't think it rises to that level, given the responsiveness of the candidate, but I think there was a technical violation, and so I would move that we find a technical violation and issue a letter of instruction, and that would be the end of it.
So there's been a motion to find a technical violation and issue a letter of instruction. Is there a second?
Second.
Okay, there's been a motion and a second. Is there any discussion? No discussion. Then we're ready to vote. All those in favor would say aye.
Aye.
All those opposed would say no. Motion carries. Thank you, Counselor. You did a good job for your client today, so we appreciate your presentation.
Thank you for taking us out of turn.
Thank you. Okay. Okay. Next case I've got is DeKalb County. Got two cases, 20 and 21, so let's take those in order. So we'll do tab number 21st, case number 2020-029, DeKalb County. Ready for the Secretary of State, has the floor.
Yes, this is a continued case. The report was heard in the December of 2022, and the SEB board requested additional follow-up due to complaints 2, 3, 5, and 6. And those were 5 polling precincts had poll workers who appeared to be untrained and disorganized. Allegation 3, 2 precincts experienced equipment failures. 5, 1 precinct received its voting equipment after the precinct opened. And 6, 7 precincts did not open on time. Out of those, there were 3 violations that were found. On allegation 2, it was alleged that 5 polling precincts had poll workers who appeared to be untrained and disorganized. The director at the time, Ms. Hamilton, advised that she and her staff had quite the challenge due to the COVID protocols that were in place, and the 2020 election was different than all the other previous elections she had been involved in. Ms. Hamilton advised training was provided to all poll workers. However, most of the poll worker training had to be conducted virtually. Due to the pandemic, there was very limited in-person training. Training began in January of 2020 and continued in sessions until the week prior to the primary election. 2 precincts experienced equipment failure, printers and scanners. The investigator attempted to contact Cassandra Mosen, the poll manager at the Reedon Elementary School, with negative contact. There was no listing for poll manager contact on the roster for New Birth Mission Baptist Church. According to a follow-up call with Erica Hamilton, she could only recall that some poll workers did not realize that the printer had to be powered on after the BMDs were powered on, and once the poll workers had all the equipment powered on, the issue was resolved. Ms. Hamilton could not confirm if that was the issue at the elementary school, and the investigator had been unable to locate anyone with knowledge of records from the in-house command center during this election time. Latasha Howard no longer works for the DeKalb County Elections Office. The investigator attempted to inquire about these records with the current director, Keisha Smith, and the registration manager, Twyla Hart, to ascertain if they had any records available, but they have not received a response. It's the date of the report. Based on information reported by the vendor No Inc., there is evidence to suggest that DeKalb County Board of Elections and Registration violated OCGA 212328A when they developed voter check-in equipment, poll pads to the wrong precincts, and OCGA 212328A, which stipulates the superintendent shall deliver the proper voting machines or voting machines and properly furnished with ballot labels to the polling places of the respective precincts at least 1 hour before the time of setup. Allegation 5, Ms. Ethel Bird, the poll manager at Canby Lane Elementary Precinct, alleged that she could not locate the key to unlock the ballot marking device, the cabinet. Ms. Bird explained that when supplies were retrieved for Election Day, there should have been 2 keys to the BMD cabinets and an envelope with the supplies. She stated that she could not locate the envelope with the keys, so she sent a poll worker to a nearby precinct to borrow one of their keys. Ms. Bird stated that once Election Day was completed, she returned her supplies to headquarters, and the envelope was located at headquarters and had never been placed in her supply box. Based on the information provided by the poll manager at Canby Lane Elementary School, there is evidence to suggest that the DeKalb County Board of Elections and Registration violated OCGA 212401A when they failed to deliver equipment and/or supplies necessary for use in a primary election. Allegation number 6, it was reported that 7 voting precincts did not open on time. These allegations were due to incorrect PIN numbers to start the BMDs. Emails and correspondences were requested through the DeKalb County IT department to verify these allegations. There were no emails that were forwarded by DeKalb IT regarding actual Election Day PIN issues. According to Mr. Greenwald, phone calls would have been the most likely option on Election Day, in which he did have a record of 2 calls for passwords PIN numbers on file, unknown which precincts called though. According to the Cross Keys High School poll manager, Jonathan Barnes, he attempted to contact the election office and couldn't make contact. He then attempted to contact his area manager, which he couldn't make contact with, as the area manager was assigned as a poll manager at another precinct due to staff shortage. Mr. Barnes contacted his previous area manager, which was able to get him in touch with the technician. Mr. Barnes stated that his precinct was out of service for approximately 1 hour due to running out of provisional ballots and the time it took for a poll worker to go to the elections office to acquire more provisional ballots. Mr. Barnes did state that a technician arrived and had the system operable before the poll worker returned with the extra provisional ballots. Ms. Harrison Robinson reported she attempted to get technical assistance. Ms. Harris Robinson stated that the issue was being the first time the equipment was used, and when the batteries were activated to start the BMDs, the machines turned back off. The issue was eventually resolved once workers determined that the power button to the batteries had to be held down until the sound of the internal fan was heard, instead of just viewing the power light illuminate. Ms. Harris Robinson estimated that her precinct opened approximately 10 minutes late. A DeKalb County judge signed 2 court orders extending polling place closing times on June 9th, 2020. The first court order was signed extending polling place hours closing at the following precincts. There was Narvi Harris Elementary, Clarkston Community Center, Medlock Elementary, Stevenson High School, Stevenson Middle School, Kittredge Magnet School, Ray of Hope Christian Church was the last one. The second court order was signed later on June 9th, 2020, extended the closing hours at all DeKalb County polling places until 9:30, citing technical and logistical issues, emergency changes to polling locations, and insufficient training and social distance requirements for voting machines. Based on the admission of the poll manager of Big Miller Grove Baptist Church, there is sufficient evidence to suggest that DeKalb County Board of Elections and Registration polling location violated OCGA 212403A when it failed to open on time.
Questions by the board? Okay, no questions from the board. We're here from DeKalb County. If you'll press your button, I'll turn you on.
It appears my button's on.
You're
Can everybody
on.
hear me?
Good to go.
Mr. Chair, members of the board, thank you for taking time to hear this today and providing me with an opportunity to speak to the allegations. My name is Bennett Bryan. I represent the DeKalb County Elections Department and our former elections director, Erica Hamilton. I'm also joined by Keisha Smith, who is our current elections director, and she's been in that position for about a year now. I'd like to first start by saying that I think it is important that we keep the lines of communication open between the Secretary of State's office and our department. And from my experience, that is in fact the case. I haven't appeared in front of this board since Governor Kemp was chair, so it's been a little while since that I've practiced election law. But I know from past elections we've been on the horn with the Secretary of State's office, with Attorney Ryan Germany when he was representing the Secretary of State's office, and I know that I think it's important that in order to administer successful elections, it does require teamwork, both between the state and between the counties, and we take that very seriously. I will say that in regards to the specific allegations of the polls not opening on time, of course that's unacceptable. Polls need to open on time. We know that. I do think it's important to note the context for this particular election. This was the primary election in June of 2020. We were at the very beginning of the COVID-19 pandemic. There were a lot of new rules that were in place, a lot of measures for social distancing, a lot of new equipment to make sure that people were kept separate from each other, plastic, clear plastic, and all of these things. This was a unique election. However, that being said, to the extent that any of these polling locations did open late, including Big Miller Grove Baptist Church, as the investigator mentioned, we did, which is our practice, is belt and suspenders. We make sure that we go to the Superior Court judge and we get that order to make sure that every voter has an opportunity to cast their ballot. We have taken some measures since this election to ensure that these types of violations don't happen again. And now we have our poll managers check in at 5:30 a.m. with a list of their equipment, making sure that we know that they're there, we know that they have access to the building, and we know that they have the equipment that they need an hour and a half before the polls open. And I think this is very helpful in making sure that these particular issues about making sure that we have the right equipment and making sure that we open on time, we're going to take care of those. So I would request that the board either dismiss or issue a letter of instruction for these particular charges. And I'm happy to answer any questions to the extent that I can.
Thank you, Counselor. Questions from the board?
Yeah, I guess what I'm looking for here is, and it could come from you in writing, or come from there, is to what specific remedial steps the county has done to make sure that this doesn't happen again, in particular in the '24 election.
Well,
do you have something that you can give us in writing?
Yes, we do have a policy in writing that we can provide to you.
Okay. To address each and every one of these allegations. I don't know if someone else has any other comment.
Question.
Okay.
How many polls opened late for the midterm elections, 2022?
For 2022, so we had 0 late openings for the runoff, and we had 2 for the midterm election in November 2022.
So a measurable improvement.
A measurable improvement, yes, ma'am. And we will continue to improve.
Yeah.
Further questions from the board? Member Gazelle? No? At this time, ready for a motion?
I would, I do believe that we have evidence of a technical violations. I do appreciate the fact that we see remedial steps being taken. I don't see any reason to send it to the Attorney General's office. I do see a need for us to find a technical violation regarding the 2020 election and acknowledge that remedial steps need to be taken and are being taken to rectify the issues.
So there's a motion for a technical violation with a letter of instruction, correct?
Yes.
Okay. Is there a second?
Second.
Okay, there's been a motion and a second. Is there any discussion? Dr. Johnston?
So is this regarding the violation of polls opening
Yeah.
late?
Yes.
Are we addressing the potential violation for Ms. Hamilton?
Which one? Yeah, we need to take those up separately. Which one were you referring to, Doctor?
It's the last
Yeah.
one.
Yes. We need to take that up separately.
So we're doing these separately.
Okay. Did you get the answer to your question? You good?
Yes, sir.
I want to make
Okay.
sure. Hold on. Yeah, let's talk about, thank you, Doctor. I think you're talking about allegation number 10?
Yes.
Yeah. Talk to us about allegation number 10. Thank you.
Yes, sir. Are we talking about the technical issues? with
13
the-
precincts experience technical issues with the ballot marking devices.
He might not have, oh, yeah, there it is. On the first page of the summary that you should have gotten, it's number 10 down at the bottom of the first page of the summary.
I guess, was that addressed in the investigator's presentation? I do apologize for not addressing that offhand, but again, it's my understanding, the remedial measures that I discussed before would also, I think, address this one as well, because not only do our poll managers need to check in very early, but they also need to check in and let us know that all the equipment is working properly. And so that in case there is any technical issue with the ballot marking device in the future, that is something that would be flagged early, and we would be able to focus our resources on making sure that we have all the equipment and properly functioning equipment, including ballot marking devices, in time for the polls to open.
I would add that to the technical violations as well.
Thank you. There's one violation mentioned at the very end of this case, and it's regarding Erica Hamilton and neglect or refusal to deliver documents.
Oh, yes, yes, ma'am. Would you like me to address that now? Okay. It is mine. Ms. Hamilton, unfortunately, cannot be here today. She is attending to her parents in South Georgia today. But it is my understanding from discussing. I believe that she was here to speak about that at the last elections board here, or at the last meeting of this board. So she has, I believe she did have an opportunity to present her side of that. But to recap that, according to her, she had her former elections coordinator, Latasha Howard, she instructed Ms. Howard to provide the information that these investigators were looking for, and it was her understanding that that information had been, in fact, delivered.
Was this information ever delivered to our investigators?
I can hear you.
I'm sorry. The information that's being referred to, was that information ever actually delivered?
No, because during when the investigator had been able to locate anyone with knowledge of records from the in-house command center, and at the time of the election, Latasha Howard no longer works, and now she no longer works for the DeKalb County Elections Office. She didn't get the records. The investigator didn't.
So is there, you want to amend your motion to take that up, or
Yeah.
handle it separately, or how would you like to proceed?
Handle it separately.
Okay. So there's been a motion to find a technical violation for respondent DeKalb County and issue a letter of instruction. That has been seconded. Any further discussion? All those in favor would say aye.
Aye.
All those opposed would say no. Motion carries. So now we need to take up the specific count against Nadine Williams, I think is. Erica, I'm sorry, I apologize, Nadine Williams. Erica Hamilton, potential violation, Erica Hamilton of 21-562B. Is there a motion?
Move to refer that to the Attorney General.
There's been a motion to refer that to the Attorney General. Is there a second?
Second.
There's been multiple seconds. All those in favor, any discussion? All those in favor would say aye.
Aye.
All those opposed would say no. Motion carries. Now, I have to apologize. We're ready to move on, but I have to apologize to counsel here. The board's attorneys are here to provide the board advice in executive session. We haven't broken for lunch yet, so we're gonna break for lunch and have executive session so that we're doing two things at the same time. And I'm sorry you're splitting lunch. I apologize. I wish I could have squeezed you in, but we're paying these lawyers by the hour. So, to protect the taxpayers of Georgia, we'll not pay for their waiting time. So at this time, I move the board to go into executive session to meet and confer with legal counsel regarding pending and potential litigation as well as administrative proceedings. Is there a second?
Second.
There's been a motion and a second. Discussion? No discussion. We're ready to vote. All those in favor would say aye.
Aye.
All those opposed would say no. Okay. So what we're going to do is we're going to go into executive session and break for lunch at the same time. I've got it that it's now 12:41, so we will not convene any sooner than 1:40. So everyone is free to be gone until 1:40 and without fear that something's going to happen in your absence. But it might be a long executive session, so I cannot promise that we will be back at 1:40, okay? But you don't have to be back before 1:40, okay? We'll stand adjourned. We'll stand in executive session. Okay. Okay.